upon notice. This is the notice.
Yes.
Lordship, may be permitted to mention one matter, Your Lordship. The private respondents, Your Lordship, have constructed illegally on PWD road land, Your Lordship. Lordship.
My lord, may be allowed to mention one extension of interim order upon notice.
Extension of interim order.
Your Lordship, I'm mentioning for item number 41. Your Lordship, these are
Called in no time, sir.
public interest litigation, Your Lordship. So it's
You want to release? Let it be called. Mention. I'll
another, Your Lordship, item number 456. The urgency is that the private respondents are encroaching our PWD.
upon notice.
My lord,
May be permitted to mention the two contempt application. It will be appear for the fresh.
Contempt applications.
my
Yes.
lord, my mention that matter for upgradation, my lord.
Upon notice.
Yes, ma'am.
What is your urgency?
My lord, petitioner are constantly threatened by my client for demolished with
Demolition?
sops.
Is that give the number? Let me see.
My lord, a contempt application, my lord.
New.
No, my lord.
This matter is under motion state. So I'm praying for upgradation because Lordship.
Upon notice.
That's what.
What is your
urgency,
urgency?
Lordship, petitioner land was taken, but without giving any compensation. Petitioner.
Give the number.
Lordship, may be permitted to mention another matter, Lordship. The urgency in the matter, Lordship, is that
Upon notice.
upon notice, Lordship.
What is your urgency?
Lordship, the matter is that the private respondents have constructed a poultry farm on an undemarcated land. The executive magistrate had passed an order for the demarcation to the BLI and LRO. The government has received the cost, but they are not complying with that order.
Your Lordship, I'm mentioning for item number 494. Your Lordship, the urgency is that it's a demarcated land, but the state authority is encroaching upon that land without any
Upon notice.
upon notice, Your Lordship.
Yes, call the list, please. Jalpaiguri circuit. Yes.
Yeah. My lord, in this matter, my lord, just morning he has come, my lord, only for this reason, my lord.
Not
I
today?
can't, yes, my lord, I play not to.
Not today?
Yes, my lord.
কালকে আসুন। Not
কালকে
today
আসুন।
করছি।
করে দেবো, আমি লিখতে পারিনি, my lord.
Matter item 1.
This matter is appearing in my instance. On a previous occasion also, my lord may remember, we are faced with a peculiar dilemma in this matter. There is an interim order against us, I would say. My lord, railways have my lord, imposed forfeit charges on us. I'll just take 2 minutes of your lordship's time.
The bank guarantee matter.
Yes, bank guarantee matter. Kindly see the interim order. The bank guarantee, my lord, had been given in lieu of certain iron ore which was still lying there. Kindly come to page 67 of the petition. This is an interim application taken out by us in the pending writ because of the subsequent events. Page 67.
You filed a separate application for this?
Yes. Yes, can number 2 of 2023. I'm inviting your lordship most respectfully to come to page 67 of that can number.
Page 67, yes.
The petitioner number 1 has apparently invested in the wagon investment scheme and is entitled to priority allocation of railway rakes for transportation of iron ore from Barbil station under a dump and load system. After the iron ore is loaded into the rake, the balance material, if any, has to be removed, failing which forfeit charges are to be imposed. However, by reason of certain orders passed by the learned magistrate Champua in proceeding under section 144 of the Code of Criminal Procedure and or administrative orders consequential thereto, loading of iron ore in several stations, including Barbil station, remains suspended till 30th April 2010. The petitioner contends that there could be no forfeit charges for the period between 6th March 2010 and 13th April 2010, when consignments could not be loaded by reason of orders passed under section 144 of the Criminal Procedure Code. There could also be no question of the petitioner being liable for forfeit during the period during which the restraint order of the learned magistrate Champua was in force. The petitioners prima facie are not liable for forfeit charges for the period during which the petitioners were prevented from loading goods for reasons not attributable to the petitioners, and in particular by reason of illegal insistence upon the payment of forfeit charges for the entire period. A strong case for interim relief has been made out. There will therefore be an interim order directing the respondent railway authorities to permit clearance subject to the petitioners furnishing a bank guarantee to the satisfaction of the chief commercial manager Southeastern Railway, securing the claim on account of bank guarantee. The bank guarantee shall be renewed until further orders of the court. The bank guarantee shall be renewed at least 1 month before the date of the expiry, etc. The last line of that paragraph. The railway authorities shall allow clearance within 3 working days from the date of furnishing of the bank guarantee. Only 8 years have passed. The bank guarantee, my lord, has been continued to be furnished by me. It has been kept renewed. Expenses are incurred, my lord, in keeping the bank guarantee renewed. The reason, my lord, why this application has been necessitated, my lord, we found information to the effect that certain quantities of iron ore, including the iron ore that was asked, are no longer there. Now, if the iron ore is missing, if the iron ore has been pilfered, if the iron ore has been sold, whatever it is, we are not liable to keep the bank guarantee, my lord, alive anymore. So we wrote a letter to them with the simple request, kindly let us know whether the goods are there and where they are, so that we can take appropriate steps in the meantime. That letter is also on record. Page 137, kindly come to the last paragraph. I've given all details, page 137. On, my lord will find this letter is dated 3rd August 2023. My lord, the last paragraph on page 137. On March 3rd, 2011, our client requested the mining department, state of Odisha, to accord permission to remove 2241.80 metric tons of iron ore from Barbil Railway Yard, so that the same could be dispatched to Paradip Port for necessary export. Thereafter, the mining department of the state of Odisha issued a show cause notice dated so-and-so to my client, inter alia alleging that in course of an alleged inspection of the inspector of mining department, a quantity of 91 metric tons of iron ore fines found to be in storage from the Barbil railway siding. Our client immediately replied to the said notice in its letter dated and further requested the mining department to enable it to accord its necessary permission to a client to enable it to lift the material from Barbil Yard. In terms of the direction passed by the mining department, state of Odisha, our client affirmed an affidavit and gave an undertaking before the mining department to the effect that after dispatch of iron ore fine, in case of shortage caused within the permitted quantity of iron ore fines, then 2241.8 metric tons, our client has agreed and ready to pay penalty fine which could be imposed upon it by the mining department. Subsequently, my lord, next paragraph. Our client, by its letter dated July 26, 2012, duly informed and furnished the said order passed by the mining department, state of Orissa, requesting them to allow our client to lift the same 2240 metric tons of iron ore from the Barbil siding. Our client made all necessary arrangements for lifting of the said material from the Barbil siding so that the same could be transmitted to Paradip Port. Next paragraph. However, despite the said order passed by the Honorable High Court in Calcutta, and despite the direction thereunder being complied by a client, and despite repeated demands being made by a client before the railway authorities, your good self failed and neglected to act upon, etc. My lord, next paragraph. Thereafter, by a communication both dated October 21, 2012, Paradip Port cancelled the iron and stored port storage plot number so-and-so and mechanical plot and began allotted space to our client, where our client used to store its material for export and its Paradip Port Trust by the said notice. Well, then it goes on. Kindly come to 139. Now, my lord, last paragraph. Now, after making inquiry, our client currently came to know that a client's material of 2241.80 metric tons are not available in the Barbil railway siding. Upon further inquiry, our client has been informed that the railway authorities have dumped our client's material at any third place, which is unknown to my client, along with the materials of other third parties. Please note that our client's iron ore fines were of very high grade, and if it gets adulterated with other parties' material, then our client will not be liable to receive the actual sale proceeds of the iron ore fine. So far, our client had already incurred a heavy loss due to the negligence of your good selves and the mining department, Odisha. And if your negligence continues further, our client will be left with no other viable option but to take appropriate legal action, etc. However, hence, On behalf of our client, we request you to kindly provide the necessary clarification with respect to the location of our client's material. Nothing done, nothing informed, we don't know where it is. And whereas, my lord, from 2010, pursuant to an order of this court on the bona fide belief that, my lord, our goods are there, will be there and continue to be there, we are providing the bank guarantee.
And they're asking us to read that.
And page 148, kindly see the last letter. Second last letter. As you know, that as per the order of Honorable Justice Indira Banerjee dated so-and-so, renewal of bank guarantee is to be done at least 1 month before the date of expiry, and intimation of the renewal shall be given commercial marketing, etc. You are therefore requested to comply with the order of Justice Indira Banerjee of Calcutta High Court dated so-and-so, otherwise it will be treated as violation. So you threaten me with contempt. You ask me to act in terms of that order. But when I tell you that I have information to the effect that the goods are not there, they have been removed to a third place, they have been mixed up with substandard goods, you do not inform me, you do not even bother to release the goods, you do not write a letter since the last 8 years. Well, that is why, my lord, kindly let them make a commitment and statement before your lordship as to where the goods are, what they have done with them, and kindly, my lord, direct my clients, my lord, not to furnish the bank guarantee in any form.
My lord,
Yes.
subject.
Yes.
Let us hear the railways.
Because we don't even mind if they sell the goods.
We had filed such an application.
We had filed such an application also, but because, my lord, at that stage, we thought that the goods are there. But now, my lord, let my learned friend first tell your lordship fairly and frankly where the goods are and whether they exist or not.
Let us hear the railways. Yes.
Yes.
If your lordship kindly sees the order passed by the 2010, my lord has already read this
Yes.
order. In compliance with the order, they have furnished the bank guarantee. First of all, my humble submission before your lordship. Initially, when the writ petition was the entire writ petition was not maintainable and is also not maintainable in the eye of law. Because
That's a different issue altogether.
number one,
We are on a limited
yes.
point now.
Now, my lord, when they have complied with the order and they have accepted since 2010 to 2024, because my lord, 2012, they have filed an application, they have not pressed for it, I believe. My lord, this is the application CAN 11671 of 2012, in which, my lord, they have made certain prayers. That I am just reading whether it is
Please
there.
confine your submission to the present application, not beyond.
No, my lord,
Because
that
I'm
is
not looking
pending.
at the writ petition now.
No, this is the application they have filed in the year 2012. Not 2010, the order was passed. Just, my lord, within 2 years, they have prayed that railway authorities be directed to sell and dispose of the said so-and-so metric tons of iron lying in Barbil Yard, best available price by holding proper auction. They have, but they have not pressed for it. Now, my lord, they have made a certain representation before the authority. Whether that is there or not there.
Is it your submission to the railways has sold the
Absolutely. Like we cannot unless and until the court directs.
Where are the goods?
The goods, my lord, what is at the point of time when the interim order was passed, that is there.
Yes.
That is there, still there.
Can you come back with an affidavit?
Yes, my lord, I shall. My lord, within 2 weeks, my lord.
Or report in the form of an
Yes.
affidavit?
Let us
Yes.
kindly make that 1 week. 2010, my lord, it was because of your lordship's
2010
gracious
to
kindness
2012, they have not pressed
have
for
got
it, and
this written.
2024, they are pressing that, yes, unless and until it is being continued.
Because according to learned counsel, this is a recent development. When the goods are not found with the railways.
Now, my lord, if your lordship kindly see what is the recent development, when we have indicated by way of a letter that yes, you have to renew it. No,
You are silent with regard to the goods.
because my lord, the court has directed.
Say that the goods are lying with the railways
Absolutely,
as they were
absolutely,
also.
absolutely.
Let that be recorded and let him file an affidavit.
Because my lord, the proper instruction will be with us, and we will file in the form of affidavit. What is there and what is not there? What is the reality?
And let learned counsel come back with a report in the form of an affidavit.
Yes.
And what about the bank guarantee? When is it
My
expiring?
lord, 4th October, till today it has not been renewed. My lord, it has to be renewed. Within 1 week, we are coming back.
It has been renewed.
It has been renewed.
Yes. Will you write us letters at least? When it comes to telling us about the goods, you don't write us letters, and only for bank guarantee,
We have indicated on 4th October, that is.
Yes,
we will give it.
Come
We will
back with
inform
the-
them.
Please come back with a report.
Well,
Let him come back with the report.
Indicating the location of the goods.
Exactly, my lord, because I cannot mislead the court. If it is not there, I have to disclose it, that it is not there.
Just a minute.
Can 2 of 2023.
Comes to be mentioned, that will be on the top.
It is submitted on behalf of the petitioners that by an order passed on 1st October 2010 in WP number 17318 within bracket W of 2010, comma, a coordinate bench of this court
ওনার কাছে ইনফরমেশনটা ইমিডিয়েটলি কে আছে ওই যে
granted an interim order directing the respondent railway authorities to permit clearance subject to the petitioner furnishing a bank guarantee to the satisfaction of the chief commercial manager within bracket FM and FS bracket closed, comma, Southeastern Railway, securing the claim on account of bank guarantee. The bank guarantee was directed to be renewed until further orders of the court, at least 1 month before the date of expiry thereof, upon notice to the chief commercial manager within bracket FM and FS bracket closed, Southeastern Railway. Correct.
ওনাদেরকে বলবে লোকাল ইন্সপেকশন করবে, ইন্সপেকশন রিপোর্টটা থাকবে, এটা জন্য আমার
Learned counsel submits that recently it has come to the knowledge of the petitioners that the materials of the petitioners to the extent of 2241.80 metric tons are not available in the Barbil, BARBIL, Barbil railway siding. The petitioners learned that the railway authorities have dumped the said material some other place, comma, unknown to the petitioners, comma, along with material of other parties which are of lesser standard than that of the petitioners. Stop. The petitioners wrote to the railway authority seeking clarification with regard to the location of the material comma, the said letter remaining unheeded by the authorities. Paragraph. The petitioners seek a direction upon the railway authorities to disclose the whereabouts of the material which are supposed to be in custody of the authority. Paragraph. Learned counsel for the respondents submits that the material in question is still lying in custody of the railway authorities as it was on the date, as it was on 1st October 2010, comma, that is the date of order of the coordinate bench of this court. That is your submission. Learned Counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 11th, next Thursday.
My lord, subject to lordship's kind sanction, my lord, somebody has to go to Barville. My lord, there has to be an inspection to that effect.
I leave it to my lord.
Yes, my lord,
But
there
give
has
them
to
the
be an
minimum
inspection.
time.
Thereafter, my
Minimum
lord, we will, because
22nd January, positive.
But my lord, that report or affidavit, may a copy be made available to
obviously,
us
I shall
before the
come.
hearing? My lord will direct that so that we can make our
Paragraph,
submissions.
report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioners.
Because, my lord, there has to be a sketch map that is to be
Yes.
done. Thereafter,
There
my lord,
has to be physically
yes, we neither, my lord, if that is not there, then my lord, I have to disclose it that that is not there.
Vice Chair.
I'm grateful.
It will appear under the same heading, my lord has been pleased to say, to be mentioned. I'm very grateful to you.
Under the same heading.
My lord, I am appearing on behalf of the alleged contemner, my lord, led by Mr. Siddiqui was there, my lord. Unfortunately, my lord, he was.
Yes,
My
sir,
lord,
the copy.
my lord, kindly, my lord, issue the rule, my lord.
Yes.
Kindly not record my submission, my lord. 10th October 2023, my lord, committee was, my lord, meeting was held for the direct purchase of this land, my lord. After that, my lord, no, my lord, improve this
So let the
situation, my lord.
contempt come before the court and explain.
My lord, kindly, my lord, issue the contempt rule. Either, my lord, no purpose will be served, my lord.
Let there be a show cause and a personal appearance as to why.
My lord,
not
my
be
lord,
issued.
my lord, my lord, my lord.
Yes.
That will work.
My lord.
It appears that the order under contempt has not been complied with till date, and no explanation has also been submitted in this regard by the alleged contemner. Paragraph, in view of the above, comma, the alleged contemner is directed to show cause, is directed to appear before this court personally and show cause as to why rule should not be issued against him for violation of for non-compliance of the order under contempt. Paragraph, the department is directed to serve notice upon the alleged contemner and submit a report to that effect on the adjourned date. Paragraph, let the matter appear under the same heading. Calcutta,
No, my lord, it's Jhargram.
Jhargram. Very well, 19th January should be sufficient.
My lord.
Item 3.
My lord, I pray not to dash because my lord, my lord, money is ready, my lord. We ask him to come and take the money for evidence.
Only not today.
Yeah, only not today. Tomorrow I will hand over.
Kindly, 8, my lord, 8. Tomorrow I have a fixed matter in the morning. But evidence service, not necessary.
কালকে দিও
No, but a contempt application it is necessary. File your affidavit of service. Affidavit of service filed by the applicant petitioner is taken on record. Paragraph, learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 11 January.
Let my client also present, my lord, before this court, my lord. If they are giving the check, my lord, client will take.
11 January.
No, চেক তোমাকে কি করে দেবো তো তোমাকে চেয়েছি
My lord,
my lord I asked him to give the details but he failed to do so my lord only for that reason my lord evidently necessary otherwise
11 January.
my lord.
Item 4.
Sir, তাহলে 11 January চলে।
he has been
My lord, I beg to appear on behalf of the respondent number.
Mr. Rao Srivastava is appearing for the state. He is on his way. You'll also kindly make it a little short password. You'll also.
Passover is not possible in this court.
I'm for the petitioner.
Yes,
I'm for the petitioner in this matter.
petitioner.
Right.
You are appearing for whom, sir?
Lordship, Mr. Rao Srivastava is appearing for the state. You'll also.
For the stay. You are appearing for?
Private respondents.
My lord, only, my lord, I am praying for your lordships, and it is very unfortunate, as per lordship desire, that I have sat 4 times, my lord, respondent number 3914.
by registered report also. Last, no return has been, AD has not returned back. It is lying. Your lordship kindly dispose of the matter.
Where is the track report?
My lord, yes. This is it. My lord, kindly. Earlier occasion, my lord, track report is same. Today also same. My lord, can you see? Thrice, my lord, can you see? Same Usti AC. Last, my lord, can you see? Last. Same OC, Usti ESO. And all these also can you dispose of the matter to considering the representation. My lord, here, my lord, is.
Yes, item bagged. Where is the next track report?
My lord.
This is item bagged. So where is the subsequent track report?
Subsequent, subsequent, last by AD, the tag report is there.
Yes, it says item bagged. It
No.
should be item delivered.
ESO, Usti ESO, delivered and.
Yes, delivery location Usti ESO.
ESO, Usti.
Yes.
ESO, Usti.
Yes.
So is sub office.
Yes.
Sub office, right.
So it's item bagged. It is not delivered as yet. It has to be delivered.
That is correct, my lord. 4 times. That is 4 times. My as per your lordship direction, as per lordship pleasure, I have served. My lord, here, my lord, we are respect about 2, 1 and.
Issuance and service is not the same, sir. You have not served at all. Item bagged doesn't indicate service. You have to serve and come back. Where are the subsequent track reports? This is on 29th September.
Last, next, my lord, last. Last, my lord,
11th
by AD, through AD,
December.
through AD.
11th December,
My lord,
item bagged.
by,
So the subsequent track reports? After that?
after the tag report is within, there is, my lord, I am giving my tag.
The last track report shows item bagged.
Yesterday, my lord, I took.
Track report, yesterday.
My lord. My lord, you also direct the OC. Who is the OC, my lord?
No, item. Why will I direct the OC? It is not being served at all. No question of directing the OC.
Yesterday, my lord, you obtained, my lord, yesterday. My lord, I can see tag report. Hand
Which
copy.
one did you obtain yesterday? This is
My lord,
12.
My lord,
4th December. Which one did you get yesterday? There is no yesterday's document.
Presentation, what does it mean?
There is no proceeding. You have to get the subsequent track reports.
Madam, may I make one humble prayer? Madam,
Yes.
if your lordship kindly takes up page 50 of the writ petition.
It has to be served first.
Yes, my lord. No,
Unless it is
Kindly.
served, I cannot take up the petition at all.
I am appealing on behalf of the two respondents, two of the private respondents.
Yes.
But kindly consider page 50.
Oh,
I cannot go into merits unless the service is complete.
Because we are unnecessarily being harassed. It is their own document that we are possessing our own portion. That is the document.
My lord, subject to your lordship's kind approval. Now, my lord, I am appearing on behalf of the state respondents. There is a representation at page 51. Now, my lord, subject to your lordship's kind approval.
Because this becomes a ground for appeal later on.
Right.
The private respondents will go to the appellate court and say they have not been served.
Right.
Service should be there, isn't it?
Right.
Please serve and come back, sir. I can't help you otherwise.
I am helpless, Lord.
Yes. Item bagged, there should be subsequent track reports showing service. It's only till item bagged. And where is your document taken yesterday? I do not find any yesterday's document.
My lord, this is last, my lord. This is last, my lord, tag report.
Please see the date, sir.
My date, my lord,
December.
I could not find much.
Item bagged is the last endorsement. It should be item delivered.
Item back, item is with the ESO. In the nearest post office. With the ESO is the nearest post office.
It should be item delivery confirmed. Unless that
that is true,
endorsement is there, I cannot take up the
Yes,
matter,
yes.
sir.
I am not disturbed.
please
I'm
do
not
that.
disturbed about that.
Let's do that.
My lord, I'm not disturbed.
Please find out the subsequent track reports.
Fine.
Since service upon respondent numbers 13 and 14 is still not complete,
I'm not
let the
disturbed.
matter stand over till 30th January
My lord.
30.
I shall take another stag report.
The subsequent track reports.
I shall take subsequent. Yes, yes. Yes, my lord.
Next.
Item 5.
Also take my subsequent. Also get.
May please, your lordship. Well, pursuant to lordship directive, my lord, everybody has been served and now they're appearing. Now, my lord, this is unauthorized construction.
Give me a minute, please. Yes.
My lord, we made,
Appearing for the response, Mr. Dey for the state? Private respondents, anyone? You're appearing? Very good.
my lord, we made series of representations from page 35 onwards.
Unauthorized construction of
Yes.
PWD road?
No, no, no. Irrigation.
Irrigation land.
That is 62 Act.
Subdivision of SDO.
62 Act.
SDO is the authority.
Where is your representation?
My lord, from page 35 onwards. Series of representation. My lord, but all this, well, frankly speaking, all the representations
Are identical.
identical and not so comprehensive.
So you want to file a comprehensive
Yes,
representation?
yes,
Very
yes.
good.
With that observation.
Yes, private respondents need, do you want to say anything? You will be heard by the authority. Yes. Affidavit of service. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining their property, thereby obstructing their egress and ingress. The petitioners seek to submit a comprehensive representation in this regard before the concerned authority and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents
Thus, 10.
that the 10th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation ventilating their grievance before the 10th respondent within 2 weeks?
Yes.
Within 2 weeks from date. Stop. The 10th respondent is directed to consider and dispose of the representation. Dispose of the miss consider and dispose of the representation within 3 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law.
অনেক দেরি আছে ভোটের এখন অনেক দেরি আছে I'm grateful.
Next.
দাঁড়াও টাইম দেবো দাঁড়াও না দাঁড়াও
Yes.
মানে 10 years I am hunting for some my compensation money. All the shop room has already been broken without any complaint. But your lordship will find, your lordship previously passed an order directing the district magistrate to take action. He has passed an order, direct the executive engineer to measure it and take a decision. 2010, I am court to home. And he has not been taken. I have already page 57. If your lordship see the page 57, your lordship will find.
Have you seen this order, the earlier order, Mr. Dey?
Yes,
So please comply with this.
No, I have handed over to him.
Please comply with this in the meantime.
Page 57, once kindly see one. Page 57. This is the survey commission, madam. I have 57. Already I measured it. 3 decibel of land he has taken without any acquisition.
The survey has been done already.
Madam, it is the private survey of me. They did not do.
Let them do the survey and come back.
Madam, with
No
notice they
further
will do
time.
the survey. With notice.
Yes, and in presence of the petitioner. To serve notice. A learned counsel for the state respondents seeks further extension of time to submit the report as called for. Paragraph, as a last chance, the prayer is allowed. As a last chance, the prayer is allowed. paragraph, let the matter appear under the same
Executive
heading on
engineer.
2nd February. Next.
Seven. Item 7.
Yes.
Yes.
But I am for the added respondent.
No, this is your reply. The opposition filed by the supplementary affidavit filed by the Metro.
But may I get a copy of this?
Please serve a copy. Who's appearing for 3 and 4?
Yes.
You're appearing?
Brother, একটুখানি চলে যাও so that you can stand.
No, receive তোমাকে করতে হবে না।
ও আচ্ছা।
কপিটাই আছে তোমার।
It's a reply to the opposition লেখা আছে তো। আমি দেখে নিচ্ছি আসলে।
Kindly come to the rear of the repetition, page 21. Page 20.
Yes.
And you come to the from prayer 3 man.
Yes.
The read of and on the nature of the certificate passing the notification dated such and such published by the government of India in the official gazette subsequently published in the Times of India dated such and such competent authority Metro. The read of and on the nature of circularity passing the order dated 1/7/2022 passed by the competent authority objection case number 5 objection cases there. So my lord, their prayer for quashing the acquisition procedure as well as my lord regarding the against the acquisition procedure.
The objection cases, yes.
Then my lord, kindly come to the order of the authority. 100
Are you on maintainability?
I have the RBI.
Are you on
petitioner?
Yes, that's why I'm asking. Are you on maintainability of the writ petition? No, you're on merits. Yes. So let the petitioner submit first.
For a moment, kindly my lord,
Let litigation complete, then we will answer.
kindly see the what is the problem. Matter is my lord pending my lord for long time, and for this reason my lord the project work is not completed.
So let the petitioner make his submission first.
আমি এদিকে যাই, তুমি এদিকে।
Yes, Mr. Gupta.
Yes, ma'am. My lord, kindly see that the notification was issued for the purpose of metro work under section 7(1) of the Metro Railway Construction Works Act
Yes.
1970. Lord, so far the first movement it relates to Lord number 1, premises number 1, National Library Avenue. Lord, the petitioners before your lordships are tenants in respect of the portion of the premises. Lord, initially by notification, earlier first notification, the portion of the 105 square meter was sought to be acquired. But it is a separate portion of the building. Lord, we raised no objection because it didn't affect us. But subsequently, when the second notification after a year was published, we found that it will affect our interest. Then, Lord, we raised our objection. And we pointed out in our objection that it is not for metro railway work, but it is for some other purpose. That other purpose is this, Lord, we came to learn in the it was in the year that this notification was issued for the purpose of acquiring the property to compensate Nepal Consulate General. Nepal Consulate General. And Lord, the Nepal Consulate General property is adjacent to the premises number 1, National Library Avenue. But when the writ petition was moved, it was pointed out that in our objection, specific name of Nepal Consulate General was not mentioned. And Lord, accordingly, Lord, we pointed out in the written submission made before the competent authority that this is acquired for the Nepal Consulate General. From the other documents and communications, we have ascertained it.
Lord, then your lordship permitted us to file a supplementary affidavit. Lord, supplementary affidavit was filed. The railway authority, Lord, they sought for permission to file affidavit in opposition. They filed. Lord, now in the opposition, the real state of affairs has come to light. Lord, they have said that it is for Nepal consulate. Lord, so far the first notification and second notification are concerned, Lord, you will find the Nepal Consulate General's property is not found in the notification. But behind the back, in the plea of public interest, they are going to do this. As soon as we pointed out, Lord, kindly see the order passed by the competent authority. Your Lordship, kindly see the last annexure. I will point out, Lord, their affidavit in reply in opposition where they have admitted it.
Last annexure to the supplementary affidavit.
No. Last annexure to the writ petition, Lord, that is the order.
105.
105.
তোর কপাল ভাড়া সত্যি
Lord, got it?
Yes.
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 Lord, your Lordship, kindly see here first page. The case of the objector in short is that he is occupier tenant of the property situated in premises number National Library Avenue, such and such, and he runs his business from the same. From the newspaper, he came to learn that the property is going to be acquired by the opposite party Metro Railway, and it is his contention. The OP Metro Railway has not clarified the reasons for such acquisition. It is his further contention that the opposite party Metro Railway is allowed to acquire the said property, then his livelihood along with livelihood of his entire family would be jeopardized. And therefore, he has prayed that the opposite party Metro Railway should be directed to leave an area of such and such from the said premises so that he and some other objectors who are also tenants in the said premises can make some amicable arrangement among themselves and can run their respective business therefrom. On the other, it is not the intent contention, he has not recorded our content. On the other hand, OP Railway by filing counter objection has submitted the intent to acquire the piece of land as the same will be used for public utility service. Now, kindly note it, and not for the any personal professional gain. They have further submitted that considering the plan of the project, it is mandatory that the said plot of land is acquired as failure to if acquired as failure to do so would frustrate the entire project. They have denied and disputed the contention of objector contained in the objection petition. However, they have stated that they are ready and willing to pay compensation as per existing laws to the land loser in the event of acquisition. I have given regard to the submission of both parties and have also gone through all the documents in the record meticulously. From the record as well as gazette notification, it is found that the acquisition is proposed for the utility and interest of the common people at large, and the project will cause development and scope of further employment and development of the nation. I am of the opinion the objection of the objector is incapable of holding any water, and moreover, since the objector will be at liberty to file claim case in due course for obtaining award for compensation in the event the land is acquired by the opposite party Metro Railway, I am inclined to disallow the objection petition. Moreover, the owner of the said premises has given consent to the proposed acquisition, and the status of the present claimant is that of possessor stroke occupier. I do not find any provision, kindly note it. I do not find any provision in the Act whereby it can be said that the claim of objector can be sustained. If the claim of the objector is to be allowed, then in that case, no authority can ever acquire any land in any area, as in every case, occupiers should come and ask for release of the land they are occupying from the scheme of acquisition. I find no justification in the prayer of the present objectors, and accordingly, it is ordered that the instant objection petition objector is hereby dismissed. Lord, he has said that we have no right. First point. Second point, Lord, we raise the question that it is not for the Metro Railway purpose. Lord, your Lordship, from the notification it appears. Your Lordship, kindly see the notification.
53.
Lord, page 85. The second notification. This is under challenge. Page 85.
Yes.
Whereas the lands, buildings, streets, roads, passages of the right of user or the right of user or right in the nature of basement therein specified in the schedule are required in connection with the construction of underground metro railway located within the span of metro corridor from Mominpur to Esplanade, section Joka BBD metro corridor. Lord, this is the purpose. Your Lordship kindly see, in this notification, your Lordship will second page. Lord, serial number 4.
Yes.
For the second time, Lord, 532.634 square meter is further required. Lord, it is kindly see, it is regarding number 1 National Library Avenue. This is not the in which we are tenants. This is the property in question. Lord, here in this notification, you will not find that Nepal Consulate General's building is being acquired. No, nor in the first notification, Lord, your Lordship will get it at page. I'm giving what? Yes. Lord, your Lordship will get it at page 50. 53. Lord, here also same notification. It is at earlier point of time.
Yes.
And Lord, at page 54, National Library Avenue only 105 square meter. Lord, now, Lord, we pointed out that it is not for the purpose of metro railway, but it is for the purpose of some other purpose, which is not. Lord, kindly see the affidavit used by the metro railway. Respondent number 4.
The reply.
Lord, yes, they have, it has been termed as reply.
Yes.
Lord, your Lordship will get it. Lord, your Lordship, kindly come to page 2, paragraph 4.
Yes.
With reference to the statements and submission and allegation made in paragraph 2 of the supplementary affidavit, I say and submit that the Metro Railway Kolkata intended to acquire 532.634 square meter of land pertaining to premises number 1 National Library Avenue, Kolkata, such and such. The price of land as in question as the same will be used for the public utility service, the piece of land as in question as same will be used for the public utility service and not for any personal occupation and gain. In conformity with the plan of the project, it is mandatory that the said plot of land is required for the purpose of execution of the project. As failure to do so will frustrate the entire project adjacent to premises number 1 National Library Avenue, Kolkata, on the northwestern part of the premises held by Consulate General of Nepal, CGN, a sovereign land is located about 409.538 square meter of CGN land lying within the acquisition alignment is fixed, frozen, and separable required for the execution of the project. Your respondent gave leave to file entire map showing the project land of the said metro project and invites the petitioners to inspect the said map, if so desire, upon notice to the advocate of the respondent number 4. But this map has not been produced, nor as stated that it is required for the purpose of metro work. But in the notification, neither of the notification indicates that the Nepal Consulate General land is notified for acquisition. Nowhere. Now, Lord, can you see that the Consulate General of Nepal did not agree to depart their land. Lord, we are also not agreeing. Depart their land, citing that due to such acquisition, it will lead to the compromise with safety and security of their premises. But for the interest of the flagship project with national importance of Government of India and State of West Bengal, Consulate General of Nepal agreed to depart acquired portion of the land lying within the acquisition alignment. If and only if the exchange of adequate quantum of land with the land from the adjacent premises to restore safety and security of the premises is order. Unless Consulate General of Nepal land is compensated with the adequate quantum of land from the adjacent premises, the project work will frustrated in its entirety. So, it was obligation for the purpose of the implementation of the project to acquire added land from the adjacent premises. National Library Avenue, 1 National Library Avenue, Calcutta, Kolkata, 7,27,000 for necessary swapping of land with Consulate General of Nepal land. The land being held by the Consulate General of Nepal is governed under the Ministry of External Affairs and involved international relation with the bordering foreign country. The issue being sensitive and delicate was taken into consideration with due earnest. So, exchange of land from the adjacent premises with Consulate General of Nepal land is an integral part of acquisition of land for the purpose of execution of the project. Moreover, it is most relevant that the owner of the premises number such and such has already given their consent for the proposal of the acquisition and file application claiming compensation in the court of learned competent authority, Metro Railway, Calcutta. The owner also agreed that status of the instant writ petition are occupier of the subject land. That the instant writ petition being the occupier of the land, the claim of the objector being occupier against the notification cannot sustain as per provision of Metro Railway Construction Works Act as amended in 1987. As per provision of the Act, any order made by the competent authority under subsection 2 of the section 9 of the Act 1978 regarding disposal of the objection in respect of the acquisition shall be final as per provision of section 410 of the Metro Railway Construction Works Act such and such as amended in 1987. A declaration made by the central government by notification in the official gazette that the land, building are vested absolutely to the central government shall not be questioned in any court of law. That the acquisition of 532.634 square meter land is the utmost necessity for the purpose of project as good as external affairs issue related to the international relation with foreign ally country. However, the occupiers may claim compensation as envisaged in the Act as per provision of subsection 2 of section clause 13 of the Metro Railway Construction Act such and such. But now, for kindly see, for the first time, when we pointed out that in the Right to Information Act report, they said that it relates to External Affairs Ministry. For the first time, my lord, we pointed out it, and thereafter supplementary affidavit, we find out it is for Nepal Consulate General. Then only, my lord, by filing affidavit, they have disclosed all these things. And we are nowhere in the notification they have mentioned that Nepal Consulate General's land is required for the purpose of metro work. It is not notified. Well, everything has been done behind back in the plea of public purpose. And that is not a public purpose. Nepal Consulate General will lose nothing. Well, they only grant passport and other things, Consulate General. He has no other function. It can be done anywhere. And adjacent land is taken for the to compensate the Consulate General. The law is settled. It can't be done. You are acquiring the land for metro purpose and you are giving it to Nepal Consulate General. Lord, your Lordship, we have in our reply also, we have stated in our reply that the landowner and Lord, the Metro Railway and Consulate General, they are in collusion with each other. Lord, initially, landowner Lord, initiated proceeding for eviction under West Bengal Premises Tenancy Act. He failed. Thereafter, Lord, the some indirect method tried to demolish the building by issuing notice through corporation. Calcutta Municipal Corporation, the building is dilapidated. That notice was challenged by us before this honorable court. The Honorable Justice Jyotirmoy Bhattacharya, as his lordship then was, quashed the notice. Thereafter, no steps were taken by the. Now, Lord, they are taking opportunity of this in collusion with Consulate General of Nepal and the Metro Railway. They are going to surrender their land. Lord, our right is there. We can very well question, and but particularly it is for the mala fide purpose, not for Metro Railway purpose. And it is held by the Honorable Apex Court repeatedly that it can't be done in this manner. As the government is dominant, in a position of dominate everything, they cannot do anything in the plea of public purpose.
Let us hear the Metro Railways. What clarification do you have?
Submission is kindly considered the
Admitted position, you are not acquiring the land for Metro Railway purpose. You have acquired
the land. I am for the RBM. Land was acquired by the Metro. I am for the respondent number 2 1. Admittedly, my lord, that land was acquired for the purpose of Metro Railway project. And my lord, apart from this,
your
I'm coming on that one. I'm coming on that one. Kindly see, my lord, who are they? Petitioner, they are claiming they are the tenant.
occupiers, yes.
Occupiers.
Interested persons.
That is a disputed question of fact.
It is admitted.
Admitted.
Second thing, my lord, kindly, it is not that what is the right of a tenant or what is the right of a landlord. When landlord have no objection regarding the acquisition, then whether the tenants have any objection, my lord,
The
that
law
can be
says so.
sustained.
Yes, the tenants are interested persons
Yes.
who are occupying the premises.
They are interested person. In that case,
And that is admitted
they
by.
can only get the compensation amount. And my lord, the writ court is not for deciding for compensation amount. For this reason, another forum is there. Kindly consider your
Acquisition has to be for the for public purpose.
Yes.
But you have admitted that the acquisition is not for public
That is
purpose.
for the public purpose. Kindly see the map, man. Kindly see the map. That is the project map.
Please come to the, that I'll see later on.
Notification.
Please come to your reply to the supplementary affidavit.
I have got the RBNL. That is respondent number 2. Reply is filed by the Metro Rail. So, my lord, the landlord has already taken the first phase portion compensation amount.
Maybe.
And second phase portion compensation amount, this is under process.
Who is appearing for the second respondent?
Second respondent, RBNL, I am.
And the Metro Railways?
4.
Yes? Admittedly, the land of the petitioners is being acquired for the purpose of giving it to the Consulate General of Nepal.
It is not the land of the petitioner, man. Kindly consider that. It is the land of the added respondent.
Yes, but the
He is the
petitioner is
owner.
occupation. Petitioners are interested persons in respect of the
Yes,
same land.
my submission is other than the landlord, if there is any other interested person, they can only get the compensation amount.
They can also
And
raise objection. Please
authority
come to
is
the
ready to
notification.
pay.
Please come to the notification.
Authority is ready to pay.
Please come to the notification.
So, my lord, for this reason, they have to come with for claim
Any
before the appropriate
interested-
authority for
not
compensation.
necessary. They are against the acquisition itself. How can you acquire for a
My
private
lord,
entity?
the landlord, admittedly, landlord has
I
no
think the Metro
objection.
Railway has to answer. Yes. You have admitted that you are acquiring for the Nepal Consulate General and not for the Metro Railways. Please come to your reply.
Kindly come to the is 3.
Yes.
Last 6 matters.
You have come to a deal with the Nepal Consulate General. You want to take his land and give the petitioner's land to him in exchange. Can you do that? Where is the law? Since petitioners are ordinary citizens, you are snatching away their land and giving it to gifting it to the Consulate General of Nepal.
So that is the not this will 6 line. The land being held by the Consulate General of Nepal is governed under the Ministry of External Affairs, and that is involved in international relations with the foreign. The issue is being sensitive and delicate once taken into the consideration with the exchange of the land from the adjacent premises with Consulate General of Nepal. That is an integral part of the acquisition of the land.
And this adjacent premises is the petitioner's premises. Where is the law? Where is the provision? How can you take away the petitioner's land to give it to the Consulate, Nepal Consulate General? Please show me the provision. You can acquire for the purpose, for public purpose, for Metro Railways, right? You are not acquiring for Metro Railways. You are acquiring the Nepal Consulate's land for Metro Railways, and in exchange, you are giving him the petitioner's land. Where is the provision, sir? Please show me. Yes? And this is admitted, right? The petitioner's case is admitted by the Metro Railways. Further instructions. You have admitted the case, sir. What further instructions will you need? How can you improve on this? Mr. Pan, anything to add?
Yes.
Mr. Pan, please assist the court. Is there any provision for the purpose?
But look at the situation on and from section 10.
On and from?
Section 10.
I need the...
Kindly turn to page, kindly turn to page 53 once.
The first notification.
First notification. Admittedly, my property was acquired partly by this notification.
Yes.
And the last notification, it is submitted to the lordship that they are ready with the check, payment will be made, as if in respect of the second notification. That is the incorrect statement.
That's the first notification.
And till today, I am not aware whether I have payment has been made or not. That is respect to the first notification. Now, kindly come to the section 50, page 53, manner 1.
Yes.
whether land, buildings, streets, roads, passages of the right of user or right in the nature of easement therein, specified in the schedule, are required in connection with construction.
Yes.
No, not for the purpose of construction of the metro railway itself, in connection with. In connection with, subject to your lordship correction, my lord, my way of understanding is this. But shifting of the premises also. Suppose, my lord, I am doing another matter, CMRI, where the same acquisition process has been done. A portion of the building has been damaged. Now, a portion of my building has been acquired. Even assuming that has not been acquired, and by the way, I'm making a second notification. Even then, I can approach the authority to acquire my land.
Yes.
Tenant cannot object to that. But tenant has got, at best, they can ask for, my lord, although I am not supposed to advise them, they are well protected under the 2013 Act. Well protected. They will get the rehabilitation and resettlement award. They will, because, my lord, now, as of date, now the provisions relating to 2013 Act will apply for the purpose of determination of compensation.
But Mr. Khan, are we not giving a very wide?
Kindly similar. Next, kindly turn to, my lord, page 85 once.
This is a very wide leverage being given to this. In connection, does it mean everything?
I will try to find out a judgment which I suffered. My lord, in the Jadavpur area, a property was acquired for dancing school under Act 2. And court held this is a public purpose.
Dancing school.
Dancing school is a public purpose held by this honorable court.
No, but that's
Now, kindly see, my lord. My lord, I come to your lordship, my lord, that in connection with first notification. Now, kindly have a look at the spirit of the second notification.
Same thing is stated.
My lord, required for public purpose. So, in connection with, my lord, what is the situation prevailing at the land? Adjacent to my is the consulate.
Yes.
So they said they will not part with the possession until and unless they are being adequately
Can they
fitted or
say?
something like that.
Can they say?
It is whether that they can say or not, possibly tenant can object. It's a national interest which will prevail. Which will prevail. Suppose, my lord, if I surrender my property for acquisition, can my lord tenant prevent me? Or can court prevent me? My subject to lordship correction, don't misunderstand me. Possibly no court of law can prevent me if I accept the acquisition. Only thing, my lord, you want us to see whether the land users are adequately protected or not. In the Act of under the Metro Railways Act, there is no such protection. But under the 2013 Act,
there is, yes,
adequately protected. Adequately protected. Because, my lord, I am not in a position for the purpose of 2-3 people cannot use my building. Because part has already been acquired.
Yes.
And, my lord, till today, in connection with, my lord, CMRI, I applied for the structural stability report. Till today, we have not received it. So I don't know what will happen to the future after the metro railway will fly.
CMRI, St. Thomas School, all these public properties are also
public properties are also in we are parted with the possession.
Yes.
We are parted with the possession. In fact, I have advised them to approach to the authority for acquire another portion of that land so that I can protect my building. Or let me know what is the structural stability of building so that I can protect my building. Because there are ICUs there, they are there. So, my lord, kindly have a look at this, my lord, that he was allowed to raise his objection within 21 days. Kindly have a look at the objection they have raised. Kindly have a look at that.
Where is it? At page? 100?
Yes. 100.
This is the objection?
Yes, sir. Yes. Now, paragraph 2. Paragraph 1. This is the first point. Proposed acquisition is totally malafide, illegal and not for the purpose of construction of project of metro railway, but some other purpose and not connected with the said project. Lord, I could not follow where from he is getting from the project itself. Because schedule of land is there, premises number is there, area is there. So that is required. Now, my lord, suppose if property has been acquired, land vested with the state, I lose my right title interest.
Yes.
Now, tomorrow, if state transfer this land to some other persons, as your lordship is dealing in my matters also, that KMDS transfer this. Lord, I cannot say anything to them. The moment it is vested with the state, my lord, is the state, my lord, domain, how to deal with this.
Yes.
Now, this is the purpose for the public purpose, my lord. The Metro Railway Authority is acquiring the land. Subsequent to acquisition, my lord, they will deal with the property. Not that before acquisition. So the moment section 10 is being, my lord, published, then property vested with the state free from all income process. Not thereupon, my lord, the moment this is being vested, my lord, only thing, my lord, what can be challenged? Suppose boundary is not there, identification is not there, that can be challenged. I can state before the authority, look, your identification in the notification is incorrect or not specific. For that purpose, I can raise my objection. But at the any material point of view, I cannot object to any acquisitions. It's for the public purpose.
That is the question raised by the
public purpose. Admittedly, my lord, in this objection, they have never said. They have said that I have connived with the metro railway. But can I? Yes. My lord, this is the decision. My lord, kind have a look at the, my lord, the act itself. Who are the party to this acquisition process? Before section 7, my lord. Kind have a look at the section 6 once. Section 7 is not an automatic process. Prior to this, section 6 is required to be complied with. I don't have any access. I was not aware even.
You're harping on any other work connected therewith.
Exactly, my lord. Subsequent to this, following this, my lord, section 7. Suppose my name is not appearing, or premises number is wrongly written, or any area has been wrongly mentioned, I can object to that.
Section 10 declaration has been made.
Made.
With regard to both the notifications.
Both the matters, both the vested with the kind. Have a look at the section 10, my lord. Can you take the travel to section 10, go through the section 10?
I've seen that.
So it's a vested with the government. It's a statutory vesting.
Do you want to come back?
আরে তুমি নিজে বলবে না অজয়দা আসবে জজ সাহেব যেটা বলছে সেটা বলো নাহলে কমপ্লিট করো
Yes. You want to wait for your senior? Let him come.
Lord, regarding section 10, same song was sung before the another single bench. This has been.
You have the judgment.
I'll give the judgment. I'll show. Lord, that judgment justice stand on.
You have the judgment?
Yes. I'll give.
Please show me the judgment, yes.
Lord, yes.
If it's the same issue.
Lord, I have got it from net, but whether it is reported or not, I have not seen. Lord, I am giving you a copy.
Please give it on the next date.
Lord, yes.
Or yes, you have it with you.
The same stand was taken by the metro.
This is with regard to section 10, isn't it?
Yes, excellent. But I shall point out before your lordship the relevant portion at the time.
Well, please do. Her learned counsels for the, oh, aaj data file hai. A reply.
Lord, they have made
When
it reply.
file the reply today, isn't it?
Yes, I have filed reply today. Lord, they wrongly mentioned its reply. It should be opposition to the affidavit in supplementary affidavit. They have mentioned it as reply.
A
I have
reply
corrected.
submitted on behalf of the petitioners is taken on record. Paragraph heard learned counsels for the parties. Paragraph on prayer of the.
Respondent 4.
You're the fourth respondent. Fourth respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st February. You want it earlier?
Kindly make it early. Because I am the worst sufferer of this.
25th January.
25th January.
Good.
May I take one indulgence because can it be at the top? Because
2018 matter. No, it's 2022 matter.
22 matters. That's
It'll appear, it's coming normally.
Thank
Let
you,
it-
Manoj. This is my-
all matters cannot be taken at the top. It'll appear.
Yes, ma'am.
Let us see.
Grateful, ma'am.
25th January. Next.
Item 8.
May I please, your lordship? My lord, I am being led by Mr. Debojyoti Basu in the matter. If my lord recalls, this is a writ petition, my lord, seeking removal of electricity poles, transformers, and other structures blocking the ingress and egress of the
Yes.
petitioner's property, my lord. Now, my lord, on the last occasion, if
The
my
joint
lord,
inspection has been held.
yes, my lord, it has been held, my lord. My lord looks at order, my lord, dated November 16th, my lord.
Yes, yes.
My lord, but please to direct the respondent number 9 to furnish a report, my lord.
You are appearing for the ninth respondent?
My lord, I appear for WBSCDCL.
That's the ninth respondent.
Ninth respondent.
Where is your report?
My lord.
Mr. Dey, a joint, yes, a joint inspection has been held.
But my lord.
Have you received a copy of the report?
No, my lord.
My lord.
Only a draft copy, my lord, as I've been instructed, only a draft copy has been received by us, my lord.
Personally given Mr. Basu a copy of the report, which is
My lord, without any photographs, my lord, we have received as I've instructed, my lord.
with all the photos. But if they so say,
Kindly gives us a
admitting
copy.
that I have not received, I may supply them a second copy. My lord, the state was not present and the Asansol municipality was not present when the inspection was done. And my lord, the photographs would. The order said that all the parties should have been present, and the photographs disclose that the transformer is not on the land of the petitioner. Annexure 3, my lord. I mean,
It was never the case of the petitioner that the transformer is on her land. It is always said that it is in front of her land.
my lord, the transformer is not in front of a land, it is on the PWD land. And the petitioner has, in a very cunning manner, placed this particular petition before the Group 1 court. Perhaps this should have been the determination of Group 9 because it particularly deals with the relocation of a transformer. And the Asansol municipality allegations have been also given that they have occupied or they have allowed encroachers to be present in front of the petitioner's land is not appearing in the matter. It
So
seems.
you say that the front of the petitioner's land is not encroached upon at all. That is your submission?
My lord, WBSCDCL is in no way participating in such encroachment. My limited submission is that so far as WBSCDCL is concerned, we are not on the petitioner's land.
That is not the petitioner's case at all, sir. The petitioner says it is in front of her land, not on her land. There is no dispute with regard to that.
My lord, my instructions are that.
It is admitted that you are not on petitioner's land.
My lord,
There is no dispute.
My lord, the petitioner has averred in some parts of the petition that we have allowed poles and other wherewithals to be
In
placed
front of her land.
in front of her land.
Yes.
But I have got, my lord, specific instruction that such is not the case as of now. Maybe Asansol municipality could take proper steps to evict the encroachers which are not in our domain.
And you say that the poles are installed far away from the petitioner's land.
My lord, the
Yes.
landlord. I mean, what has the station manager who was personally present given? I submit information.
Yes. What is your submission?
Lord,
My lord, on the last occasion, my lord, as per your lordship's direction, my lord, we have served notice. My lord, may I file my affidavit of service?
That's immaterial now. There an inquiry was directed that has been held in your
My lord,
presence.
my lord. A report to John.
And a report has been filed.
My lord, may I have a copy? My lord, may I have copy of
My
the
lord, I
report?
can
Then
give them a
I'm taking leave from your
copy of the
lordship.
You have been served with a copy, learned counsel says so.
My lord, then my lord, I am praying for a leave to take out an exception to this report, my lord.
It was held in your presence. What exception do you need to use?
These are the original photocopies, my lord. These are my lord.
Not necessary. You have given copies, not necessary. Yes.
Then, my lord, kindly keep this matter tomorrow, my lord. I am led by Mr. Devojyoti Basu.
Let him come back. A joint inspection report. Joint inspection report submitted on behalf of the 9th respondent is taken on record. Paragraph. On prayer of the petitioners, the matter is adjourned. Paragraph. Let the matter appear under the same heading on 31st January. Next.
Item 9.
Lordship, ITM 9, I appear for the petitioner, Lordship.
State.
For the board of trustees.
For the Kolkata Port Trust, Lordship.
Yes.
Lordship, may I resume, Lordship? Lordship, this is my petition, my application for regularization of my lease in a land owned by the Kolkata Port Trust, where I am a sitting occupant by way of a sublease granted in favor of another of my landlord, the actual lessee. Lordship, an order of eviction was passed against the original lessee back in December 2009, Lordship, wherein I was held to be a lawful and legal occupant. Despite that, me being and I having deposited all my rent with my landlord, the landlord was in failure of depositing rent. Hence, an order of eviction was passed. Lordship, pursuant to a circular by the Kolkata Port Trust in 2014 for grant of fresh lease under first right to refusal, I apply for that. I have written more than 6 representations till date from 2014 till 2020, last in 2021, Lordship. Post which I filed this writ petition. Lordship, all my representations have gone unheard. No response have been given to me. And moreover, Lordship, the my instructions are that Shibpur police station is taking steps to evict me from the property. Hence, this is my application for consideration of my representation. Lordship, there's a Lordship has Lordship, my representations are at page. It starts at page 102, Lordship. My last representation is at page 109, Lordship, that is June 2022. Under first right to refusal, Lordship, the circular is also annexed at page.
This is a demand of justice, isn't it?
Yes, Lordship. Yes,
It
Lordship.
should be a representation.
Lordship will kindly take note of my statement at page 111, the second paragraph, Lordship, that by the said order dated 21st December 2009, the order of eviction. Also, Lordship, I'm led. No. Also observe that my client initially came into occupation as authorized subtenant of KR Steel Union Private Limited, the original lessee, Lordship, and further pointed out that the occupation of the added party in the said eviction proceeding, other than my client, that is the petitioner herein, could be termed as trespasser to the KOPT, and directed the occupants, including my client, to vacate the said premises. Lordship, here may I point out that a prayer was made before the estate officer as well for regularization of my occupancy, Lordship, wherein the estate officer, he did not express a denial of my request. Rather, he made a statement saying that the estate officer is incompetent to pass such an order. So it's not even a case that I am in breach. No response to my representation, Lordship. For 8 years, Lordship. The first representation being that of October 24th. Yes, Lordship.
This cannot be directed to be considered. Will you file a comprehensive representation, or do you have a representation on record?
Lordship, yes. Several
Demand of justice.
No, my lord will kindly.
And yes.
I'm sorry, my lord.
Lordship.
My lord will kindly see page 102. We write to them with regard to the circular, their own circular. We say kindly regularize. Kindly takes, my lord, page 102.
Yes.
We refer to the above circular. My lord, I think my junior has pointed out that circular.
Yes.
Circular is at page 99, the right of first refusal. As a matter of fact, we are covered, we are in a better position.
These are all demands of justice.
No, my lord, we say that, my lord, will kindly see page 102.
No direct communication, that's also demand of justice.
No, my lord, will kindly see.
By the learned
My lord, will 103, my lord, will kindly see third
demand of justice by the learned advocate. Where is your direct communication with the authority?
My lord, it is by the advocates. Okay.
The advocate has intervened. Yes, before
Yes.
you filing a direct application.
I'm sorry, my lord, my junior.
That was a follow-up.
My lord, it's page 105, my lord, it's a follow-up by the client directly.
Thereafter at 107.
And also at 107, my lord.
Yeah, these are all follow-ups, isn't it? Yes, let us hear the authority.
My lord, and my lord, your lordship's decision. My lord, here the writ petitioner was a trespasser. My lord will kindly take, it's in WPO 844 of 2021.
Let the authority decide.
My lord, just for the sake of completeness, my lord will kindly take
Dollar Industries.
paragraph 11, page 13.
This was decided on merits.
Yes, my lord. And here, my lord, the writ petitioner was a trespasser. But in my case, I have been held to be a validly in possession. Paragraph 11, my lord, the right of first refusal. But here, the writ petitioner was asked to pay interest because he was a trespasser. I am not a trespasser, as per the order of the estate officer.
The sublease was with the approval of the authority.
Yes, my lord, that's recorded in the order. That's recorded, my lord. My lord kindly takes page 48.
This is the order of the estate officer. My lord, second line, KOPT by its reply dated 13/3/2009, bearing such and such, filed on such and such, mentioned that accepting Indian Oxygen Limited, Mr. Protos, Messrs. India Factory. That's us.
Where are you reading?
My lord, the page 48, second line. Let-
Yes.
KOPT by its reply dated such and such, filed on 13/3/2009 against OP's application. The such and such specifically mentioned that accepting Messrs.
Right.
India.
This is authorized.
Yes. All other sublettings made by OP are unauthorized. They have acknowledged this fact. And also, my lord, in the next paragraph, your lordship will see the last 4 lines, Messrs. Ramchand Narayan, GL Sons, that's the writ petitioner before your lordship, formerly known as Messrs. India Factory.
Yes.
So I'm a valid subtenant, my lord.
Yes.
Lordship may recall, Mr. Dotto explained. The writ petition is based on a circular. The circular is at page 90. Lordship may take the trouble of coming to this. What the circular means.
Page 39.
Page 99.
Yes.
That is happening. Kolkata Port Trust has decided to grant first right of the city of. This is important. First right of refusal. Because if we have opens on the basis of certain agreement reported or in possession.
Yes.
Without any approval, outside the investment of real property in the tendering process to be taken up for allotment of a particular land structure, both under KDS and EPC, provided they file their application in all respect, along with requisite documents within 6 months after date of application of this notification, subject to fulfill the conditions. So therefore, the question of first right of refusal will come in the tendering process.
Yes.
Tendering process means I am under the lands policy of the central government, which is binding on Port Trust. If we want to lease out any land, we have to put it on for auction. And the high bidder. The first right of refusal is that they will also be allowed, being an occupant, to participate. But they have failed to match the highest bidder. In that event, being the sitting occupant, they will get the first right of refusal.
Yes.
That means they will be given an opportunity to match that highest bidding price. Number one. So therefore, it is nobody's case that KOPT has already published any tender to let out this property to the highest bidder. There is no such case, not the case of KOPT also. Number one. That too also, upon fulfilling the last sentence, upon fulfilling the conditions as detailed below. A is the original recorded cease to exist. Here the original tenant lessee is very much in it. Number one.
But the original lessee has ceased to exist.
No, yes, there has been an eviction order.
Eviction order, but
So the jural relationship is over.
They have not handed over the position.
The jural relationship has ended.
Question of jural relationship does not arise. They are claiming through him, now we are independent, number one. That's the preliminary scope of the notification. I shall come to details later on. Now your lordship may be pleased to come to the letter at page 102. Their first reprint.
Yes.
Your circular, representing this circular is based on what they are paying for. Page 103, second paragraph.
Yes.
Be that as it may, be our client is interested to be a direct tenant of land structure under the Kolkata dock system. Well, where is the scope to grant direct tenancy? If there is an auction and if they participate in the auction but could not match the best quoted price, then they will be given an
opportunity.
Question of best, the document never says that we shall grant. Not there is any policy at all. There is no policy of KOPT to grant direct tenancy. The question of considering their
representation doesn't arise.
And we come to the prayer also. Is the writ petition maintainable if it is based on this notification? Kindly come to the prayer portion. Page 21. Rather, it's the prayer is page 21 and continues in page 22. Particular respondent 3 and 5 to show cause as to why the applications of the petitioner regarding grant of fees in favor of the petitioner over the area which your petitioner is in occupation at unauthorized subterranean, the right of the court circular shall not be taken into consideration by them.
Right.
The circular never says so.
Right. That's all your submission?
Oh, I think the petition is not maintainable because
let us hear the reply of the petition.
if any further clarification later regarding the circular, I can explain the circular in detail. The other parts are also there.
The circular is in itself very clear.
Very clear.
Initiating the tender process.
First right of proceedings are only that much. No other.
Will kindly take my lord's order, my lord, passed in WPA 844 of 2021, paragraph 11. May I just read it?
That's a different treatment.
No, they were not even authorized, my lord. They were ranked trespasser.
Even then, is there any direct? There is no direct tenant, no policy of the KOPT for.
My lord, I have been in occupation. They have obtained an order of eviction.
First right of refusal.
Yes,
that's
but they have obtained an order of eviction. Tomorrow they will evict me.
They have to take paper possession in order to.
Yes, let them take symbolic possession, but let them not throw me out of there. Let them not throw me out of there. I was a valid subtenant. That has been recorded specifically. My lord kindly takes paragraph 11 of my lord's judgment, my lord.
Yes.
Upon consideration of the entire facts and circumstances of the case and the submissions made on behalf of the party, the court is of the view that the respondent authority be directed to initiate. There also there was no tender. Initiate the tender cum auction process in terms of the notice circular issued by the authority. Here they have issued this circular in 2012 and for 12 years they have gone into a slumber. Your lordship directed them to issue a tender. The authority is at liberty to take symbolic paper possession. Let them take symbolic paper possession from the petitioner in terms of the said notice. The petitioners having occupied the premises in question on basis of an arrangement with the original lessee, but without approval of the authority. Here it is with approval of the authority. Shall have the right to participate in the tender with the first right of refusal. My lord directs them to do this. I've been writing to them from 2014. What is the purpose of this circular then? I bring out a circular and then I don't do anything about it. And they're taking steps to evict me. My lord will direct them. I will do the needful.
Yes. There is no scope. I will have to consider the judgment on what, under what context this direction. the right of refusal here also, to grant first right of refusal, provided there is tender. You cannot the Honorable Court, my lord, with great respect, the greatest respect, cannot direct Fortress to
Yes, to initiate tender
to initiate tender process.
That was exactly the direction given in the earlier judgment. So if you want to
My
go
lord,
through this and come back, you can.
Let me find out whether any appeal has been preferred against
Very
it.
well. Please do that. Please do
And let them not take any coercive steps in the meantime.
No, my lord, no interim order.
No, let them not take any coercive steps. I have given him the judgment. Court is aware of this judgment. Court is aware of this judgment.
I am opposing it.
If they
simple reason, the scope of the circular and the prayer and the letters completely different.
My lord considers
There is
prayer
no-
F. My lord, I beseech your lordship to consider prayer F. My lord, they will take time and then they will evict me and create third-party interest.
Day after tomorrow, question of evicting them within 48 hours does not arise at all. Keep it on Monday.
Yes, I have no difficulty. My lord keeps it on Monday.
Keeps it on Monday. Let me come back. But question of evicting them within 48 hours, well, they have preferred an appeal. There is statutory remedy available to them under Section 9 before the district judge. Then revision before this Honorable Court.
My lord keeps it on Monday.
Please consider this judgment and come.
Yes, my lord. Yes, I shall be coming back with necessary instructions.
But may I beseech your lordship that let the matter retain its position, my lord.
Hopefully it will. Let us see.
Great.
Come back on 9th, Tuesday.
I shall not do it.
And please ensure that there is no coercive action in the meantime.
Did not record anything, my lord. We are not going to do it.
Very,
much I know.
very well. I heard learned counsels for the parties.
They are not
That
the
the
only
matter
one.
appear under the same heading for further consideration on 9th January.
Not
grateful.
People of life.
Next.
Item 10.
Petitioner in this matter. And I have an application for addition of party. I've served the other side. This is my.
On the last occasion, your lordship, my lord, was directed me to submit the affidavit of service that I am submitting. My lord,
You've served the respondents, all of them.
yes, by hand service.
And,
You are for the
my lord,
state, madam?
all are state respondents.
All are state. No, there's the Gram Panchayat.
Private individual.
My lord, he is no way related with the land.
Have you received copy of?
No. No copy has been served.
Served the affidavit of service. I've just filed my affidavit of service.
My lord, then I have to take instruction, my lord, and I'll file opposition to that application. How he is related with this land is mine. He is outsider. He's outsider, my lord, and he is trying to mislead the court by filing this application. Erstwhile, my lord, they have filed one.
First, find out where is the application. Didi, application what is the number? 1 of 2023.
No copy of application is also in the list. No can.
And I do not find the application also in the file.
And my lord, so far my instruction, it is not yet received by my client.
No, it is in the list. It is in the list, 1 of 2023.
One is in the list.
Do you have a copy of the application?
And I have.
My lord, I have to take instruction and I will file my opposition to that application.
And it is on the basis of my complaint that the learned district magistrate has passed an order directing his eviction. It's under the West Bengal State Highway Act, illegal enforcement. Thereafter, that was not being implemented. So we came before my lord. My lord had directed the learned district magistrate to implement that. In the implementation order was passed
On the basis of a false allegation.
Challenging that the main order passed by the learned district magistrate for eviction has not yet been challenged. The order for implementation of the order has been challenged. So I do not know how is this maintainable. If it is not maintainable, I
Then, my
have
lord-
in party deliberately. So that they can somehow anyhow bring.
Lord, I will satisfy your lordship, but on the basis of the, my lord, sanction plan, I am making my construction, and my lord, there is no encroachment. There is no encroachment
The district magistrate that order remains.
on the basis of a false allegation against your petitioner.
My lord, will kindly come to page 44. That is the order of the learned district magistrate that remains unchallenged.
It might be on the basis of a false allegation.
False
That-
that not challenged. The order says not even been challenged even in this writ petition.
The order I have challenged of the learned district magistrate. Last order, my
It's
lord.
an order of implementation, isn't it?
Yes.
This is an order of implementation. Where is the principal order?
Page 44. Ma'am.
This is the 10-4 order, page 44.
13th October 2017.
Yes, is this a 10-4 order?
Subsequently, they filed a writ petition, and your lordship directed the learned district magistrate to dispose of the representation of the writ petitioner, that writ petitioner in that writ petition. And that order was passed, my lord, on 17th of August 2022.
Clearly, from the implementation of this order, this order remains unchallenged. What is there? There is nothing.
My lord, they are the neighbors. They have no locus to file the writ petition.
Even in this writ petition, the principal order has not been challenged. So how is this maintainable? I do not know. They could have challenged this. They chose not to challenge.
How has the district magistrate dealt with it directly? Was any section 10 notice served upon you?
No, nothing. Nothing.
Where is the earlier order of the court?
Lordship,
Earlier order of the court.
kindly come to page 40. And my lord, PWD is claiming that this is their their road, my lord. My lord, your lordship, kindly come to page.
Who is appearing for the state?
Oh, my lord, I am sorry, my lord. My clerk means this is not my matter.
Who is appearing for the state in this matter?
This matter.
Panchayat has specifically stated this is Panchayat road. Your lordship, kindly come to page 49.
If it is Panchayat road, he cannot construct on Panchayat road.
No, I am not constructing, my lord. I have making my construction on the basis of sanction plan.
For the state, because the state can respond to this.
But that is my application to be allowed for addition of tracking.
No, my lord, I have to file opposition to that application.
Come back with an opposition.
Yes, I'll file opposition.
It is on the basis of my complaint.
He has no locus to enter into this matter.
Admittedly, it has been initiated on his complaint, isn't it?
Yes.
So,
My lord, I am aggrieved by the order of the, my lord, Laded district magistrate. That is, I have challenged in.
It was passed in compliance with an order of a writ petition which was filed by the added respondent, the
Lordship.
proposed added
Yes.
respondent. So he is a party. He is a necessary party.
Lordship, kindly
If you
give.
still want to come back with your affidavit, you can.
Yes.
That will only be buying some more time from the court, nothing else. Since you are allegedly
Till time, I have not received any copy of the application.
That is probably not. Kindly not read it.
Have you served the state?
My application has been served on every.
Have you served the GP's office?
No, I have served, my lord, the Laded district magistrate directly, and all the respondents I have served, whom I have made party in the writ petition. All.
You don't need to serve the GP's office?
Then you'll. Now, that was the GP they serve Korani.
Because I cannot request anyone to appear unless you serve the GP's office. You have not served the GP's office.
By this time, my lord, I will serve.
Please serve the GP's office
Lordship.
and come back.
And I'll file the opposition to this application.
The pendency of the writ petition in that case should not be a stay.
No stay has been granted.
No, sir, I will kindly make it clear because the order is not being implemented, citing the pendency of this writ petition.
Is there any stay order? No.
No, there is
Then?
no stay order, man. There is no stay order, but still they are not implemented.
My lord, kindly do not take any coercive measure in this coercive action in this by this time.
Original?
Until one writ petition is pending, during pendency, how it
Every form of territory tactics has been done.
Unless you serve the state, I don't think I can pass any other order. Please serve the state and come
yes,
back.
yes.
So that
Other
I can,
all respondents I have served. Whom I yes.
Please,
That
otherwise
I'll
I
serve.
cannot appoint anyone.
That I'll serve.
I have to appoint someone and regularize the appointment.
That I'll serve.
In that case, I will kindly record that the stay has been refused. It has been prayed for and has been refused.
Not necessary. WPA তে order
না,
করুন, হ্যাঁ?
দেখে নিচ্ছি।
On prayer of the petitioner, liberty is granted to serve a copy of the writ petition along with annexure thereto at the office of the learned government pleader and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 1st February.
First,
Paragraph, Can 1 of 2023 তে order করুন। Learned counsel for the petitioner seeks to use an affidavit in opposition to the application. Paragraph, affidavit in opposition be filed within 1 week from date.
2 weeks. It is fixed. It is fixed on first.
First, yes. Very
Within
good.
2 weeks.
2 weeks from date. Stop affidavit and reply, comma, if any, comma, be filed within a week thereafter. A paragraph, let the matter appear under the same heading on 1st February.
Lordship.
Both the matters on 1st February.
Lordship.
Please serve so that I can request someone to appear.
Lordship. That I'll serve.
Next.
দেখছি document flow নামটা কি?
Item 11.
Lord, item 11, my lord, I am for the petitioner. My lord, on the last occasion, the state filed a report.
Yes.
My lord, we took an exception. My lord, on that report, my lord, few points perhaps, my lord, incorrect.
You took an exception?
Yes. My lord.
Have you filed your exception?
No, my lord. Today, my lord, kindly allow me.
So they have received a copy
Yes. That all.
today?
Sir. My lord, in that report, point number 3, they stated that all the plots are in active and peaceful possession of district police with proper fencing and perimeter wall. My lord, it is true that proper fencing and perimeter wall we have watched, but in the plot there was no possession by the district police. So the statement given by a report is false. My lord, it's true that they are not using or file this report in the form of an affidavit. I do not say that false deposition on affidavit, but I indicate, and for that reason, my lord, I use an exception. This is number 1. My lord, number 2, my lord, your lordships, my lord, on the last occasion asked me whether you challenge the acquisition or requisition process. My lord, I request your lordships kindly page at 26. Few submissions, my lord, subject to your lordships kind. My lord, this
Third plot is 116.
116. My lord, in the report.
So that's at the end of the acquired plots and they don't need it.
No. The acquired plots are in far distance from 116. They also stated in the same. Kindly see, my lord, point 4 of the report. Except the plot number 116.
All are adjacent.
All the plots are adjacent and forms. So it is completely separate. They are not in possession, not in use. So all I pray, since you are not using my land, please de-requisition. Number 1. For that, your lordships asked me on the last occasion whether I have challenged the same or not. 26 of my writ petition, I have challenged the
You
same.
have received compensation for your plot?
No. That part of, my lord, kindly see the 26. My lord, 26, my lord, my challenge. 28, their document. My lord, 26, my lord, 27, my lord. Kindly see.
26 is your request for derequisition.
Yes. My lord, 28, see, my lord. It is there. My lord, last paragraph, I again reiterate, my lord. Apparently, the release of the said amount of land may not hamper the project.
Yes.
Now, my lord, on the last occasion also, your lordships dismissed my writ petition on the ground of res judicata, to the point that that was already decided by my lord Justice Vishwas, my lord Justice Jayanta Kumar Vishwas in a separate writ petition. My lord, that order was 51. My lord, kindly see, my lord. My lord, 51 is the starting point. I request your lordships kindly come at 52. Next, second paragraph from bottom, last 3 lines. However, it is up to the authority to decide whether they will favor the petitioner with the desired release of the piece of land. So now, my lord, I sum up. I have challenged the same in one. I have challenged the same. This is on page 26. Page 28, their document, their, my lord, statement that this land is not required for the project. It may be released. Filing a writ petition, my lord, dispose of the writ petition on that ground that, see, this is a res judicata point taken out by the my lord Justice Vishwas. Still, however, it is up to the authority. I made a representation that is on page number 54.
In the earlier writ petition, you had challenged section 3.
Yes,
the notice.
yes.
Turned down.
Still, after observing everything, still, my lord Justice Vishwas come to this observation that, however, it is up to the authority to decide whether they will favor the petitioner with the desired release of the piece of land, etc.
Yes.
Now, 54 is my representation. Till date, they are not, my lord, consider my representation. So, all I pray.
It's not the representation.
My lord, sorry, my lord. Then, sorry. 56. So, my
Cannot be released.
True, but my lord, yes.
What land will
My lord, my lord, I accept. But
you
at
say
the
it has been illegally acquired. It has not been illegally acquired.
no,
Please see the first line of your representation, page 56.
my lord, illegally require why I say, my lord, that was made by writ petition. My lord, layman. My lord, all I say, my lord, since there is a document. Yes. My lord, that I understand. My lord, since there is a report made by the collector that this land is not it's not used for the project, let it be returned. So on that,
The report says it is not feasible to return your land.
my lord, may I say, my lord, the report also says they are in possession. Is it not that, my lord, I am asking myself, is it not the, my lord, incorrect statement? Because I annex the photograph of that particular land. They are neither in possession. The land is completely vacant in nature till date. After acquisition.
Vested, yes.
My lord, basic principle is this, my lord. Wherever after acquisition, my lord, is there complete. There is any necessity of anybody's position is the position.
It is admittedly vested land.
My lord, since they stated in the report, I took an exception. Still, I request your lordship, since in the order of the my lord Justice Vishwas, it is stated that, however, it is up to the authority
That
to
is neither here nor there, sir.
My lord, on the
It has decided not to
may
delay.
I say, my lord, on the very first day, your lordship, please to observe that, please consider this entire writ petition as a representation. So all I pray, only my lord, instead of dismissal, if your lordship pass this order for consideration.
You further?
My lord, it's for my lord
Can the
satisfaction.
court pass an order which will be absolutely futile?
My lord, I know, my lord, still,
Then,
since my lord justice,
there is no
my
other
lord, yeah,
way out.
my lord, Since my Lord Justice Vishwas say, however, it is up to the
Please do
authority.
not harp on the same point.
I
sir.
made this
That
representation.
was considered by the authority and turned down. The
No, my Lord,
report says
kindly consider that this representation will be
that
considered.
will not
My Lord,
help.
let it be rejected.
That will
Let
not-
it be
no,
rejected.
that will not
My Lord,
help.
let it be rejected.
No, no, that
My Lord,
will not
instead
help.
of dismissal, kindly, my Lord, this
I
consideration.
can ask
Last.
to withdraw.
My Lord, last, my Lord. My Lord, kindly treat
Please
this
do not
representation
bargain
as
with the court like
representation. No,
this,
no,
sir.
no, my Lord, no, no.
There is
My Lord,
no question of consideration of representation because the authority has given their views. There was no direction upon the authority to requisition, which is not possible under the law. It's a vested property.
True, but my Lord, still, my Lord
So,
Justice
since that is true, no, nothing further remains to be adjudicated.
But still, my Lord, after considering all these, my Lord Justice Vishwas passes these three lines that, however, it is up to the authority.
Yes, so the authority has decided not to. That part is over?
No, my that authority does not decide.
The report.
My Lord, that report was prepared by them not on the basis of my representation.
Not necessary. On the basis of the writ petition and the direction of the court. So nothing further is necessary, sir. The same observation will be taken in your representation. You can only buy some time. That's all.
No, no, there is no question of bite sometime, my Lord. All I request, if your lordships, my Lord, kindly direct them to consider this entire writ petition as a representation. And my Lord,
Sir, I repeat.
very well, my
that
Lord.
is
No question of sorry, my Lord. It is my prayer.
Not possible.
Very.
I have to dismiss the writ petition since the authority does not agree to do it. And you have no claim over the property. Vested land cannot be divested. Yes. Let it be dismissed.
Pass necessary.
Do you want to withdraw? I can give you that liberty.
Then, my Lord, I have.
Don't want to proceed any further. I can give you that liberty.
Then, my Lord, I have to take instruction.
No, that will be without liberty to file.
Then, my Lord, I have to take instruction. Can it be possible give 1 day? 1 day.
Since I am inclined to dismiss the application, I want to give an opportunity. That's what I'm saying.
1 day, my Lord, kindly give.
Not today only?
Yes.
Mr. Let it be not today. No liberty will be granted because there is no question of liberty in this matter.
Very well.
The other side will always oppose, sir.
That I can, my Lord. If your lordship fixes the matter on 2 p.m., my Lord, I will, my Lord.
I will take up group 1 matters after 2 p.m. also today. So if you can come back at 2 p.m.
Yes,
I'll just
that your lordship. That's your lordship's can take. I do not.
This is 2 p.m.
I'm good.
Next matter 515.
Oh,
Yes.
But your lordship need not open this view. I will not question your lordship's side. Now, my predecessor has come from Bangladesh in the India. They have got the land under the refugee quota in respect of Jogachi Moucha. Now, my lord, they have paid this rent, municipality tax, and the electric bill. My grandmother was also a teacher, and in staying in that address, and also pension payment order was also issued. My predecessor made an application. I also made an application. The other laborers staying on the same area have got the patta deed. But I did not get this patta deed. I made a representation, page 19.
Has got the patta.
Yes, patta deed. Under the rehabilitation department. Page 19. When I have annexed also deed, another deed that other neighbors have got this. This is page 21.
This is under the Land Reforms Act? No.
Rehabilitation department.
Patta.
Yes.
Where is your representation?
Page 19. And paragraph page 20, kindly see, I have stated also, page 20. Last paragraph.
They have been granted, yes.
Other neighbors have granted patta. I have annexed it, page 21. I have annexed this, patta deed.
Yes, Mr. Bandyopadhyay.
Hey, this is page 19. Page 19. বলছি তো কনসেপ্ট
সেটা বুঝলাম কিন্তু প্রপার অথরিটিটা কি দেখছে
ডিপার্টমেন্ট বলছি তো
বুঝলাম ওটা ঠিক আছে
এজিএম
সবার থেকে খবর হচ্ছে না সম্ভব এসডিএফ
না রিএফডিসি ডিপার্টমেন্ট
করে দেন আমার কিন্তু যত ভুল অর্ডার হলে কিন্তু আপনি
আমি তো বলছি
বলে দিন না দ্বিতীয় এখন সবার ডেলিগেট করে
Mr. Bandyopadhyay, let this be considered within 1 month.
1 month and 2 months 2 months
But respondent number 3 will be the authority.
my lord he has my lord address to the
Respondent 3.
এটা খোল
To the ADM.
Well, possibly, my lord, he is not the authority. It has been delegated to some other person.
No, he has given the
But
patta.
actually, I'm not
I have annexed the deed.
my lord.
I have annexed the deed.
ঠিক আছে কিন্তু মনে হচ্ছে এটা
না না ওই
নর্থ চব্বিশ পরগনার ক্ষেত্রে অন্য মামলা আমি দেখেছি অন্যজন আছে আমি প্রপারলি আমি জানি না কাজে বলতে পারবো না
he has given. But kindly say other department, he has granted patta. So far the other never has a concern.
Let him give it.
Yes.
He'll delegate if he wants to.
Yes.
As your lordship.
Because patta has been issued by him, granted by him.
Consider representation.
Having migrated from East Pakistan, East Pakistan sometime in 1950, the petitioner's grandfather was in occupation of the plot in question under the refugee quota, and the said occupier and his successors constructed a residential house therein. Stop. The petitioner is in possession of the plot in question till date as legal heir of the original occupier. Stop. The petitioner's grandfather applied before the authority for grant of patta in respect of the said plot in his favor.
এটা নর্থ চব্বিশ পরগনার ক্ষেত্রে হয়েছে অন্য কোথাও নেই
Since other persons occupying adjacent lands and adjacent lands and similarly circumstanced with him have already been granted pattas by the authority. Stop. The said application not being heeded to, the petitioner submitted a fresh application requesting issuance of patta in his favor on 27th June 2023, which has also not been considered. Stop. The petitioner prays for a direction upon the authority to consider the application at the earliest. Paragraph. Learned counsel for the respondents submits that the third respondent be directed to consider the application in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioner dated such and such within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Chapter.
But you will also give a direction to this point number 3.
3, yes.
Or my lord, he can delegate or he'll delegate the power to any appropriate authority.
Let him take a decision.
And he also can do that also.
একটা line add করো, ওই decision taken এর আগে যেটা করলেন।
To the appropriate
The third respondent shall be at liberty to delegate the authority of consideration of the application to the appropriate authority as he may deem fit.
Right.
Yes, next.
Video service.
516.
My lord, is my application. My lord, petitioner before Lordship, my lord, the lease was granted in favor of the petitioner in respect of a pond, my lord. Government pond, my lord, and the petitioner obtained the said lease, my lord, by paying, my lord, 24,89,646, my lord. And my lord, the pond was handed over to the petitioner on, my lord. Kindly come to my lord. Annexure, my lord. 10th February 2020, my lord. And my lord, just after this is one the month of February 2020, and just thereafter, my lord, the corona, the pandemic situation has started, my lord. And for that reason, my lord, petitioner could not, my lord, run the cultivation in the said pond, my lord, for a more than 1 year, my lord. And immediately the petitioner made a representation to the authorities to, my lord, by writing, my lord, that the lease then be, my lord, considered in respect of the said, my lord, and for exemption of the said lease then, my lord, for that year, my lord. Since, my lord, the petitioner could not, my lord, cultivated the said pond, my lord. Now, my lord, authorities has not, my lord, taken into consideration, my lord. They have imposed further lease rent upon the petitioner for further year, my lord. Now, according to the, my lord, tender notification, my lord, the lease is for 1 year, and it can be renewed one after another, my lord. My lord, but my lord, petitioner thereafter, my lord, made a representation to the authorities that they are not in a position to run their business. Let the lease be cancelled. But the same was not considered. And, my lord, lastly, my lord, a huge amount was, my lord, demanded from the petitioner. My lord, kindly come to, my lord, last annexure, my lord, page 34, 89,78,748.
This is the lease rent.
Lease rent, my lord. For the period, my lord, 3 consecutive period, my lord. My lord, but, my lord, prior to that, my lord, the petitioner made a specific representation to the authorities that they are not in a position to run their business. Yes.
Where is your representation? Page 33.
Lots of. Well,
No, 33 is not. Where is your representation?
Last representation, my lord, 24th June 2020. Thereafter, my lord, 9th September 2022, my lord. Page 30, my lord. Let it be considered by the authorities, my lord.
Page 35.
30, my lord. 30, and except
30.
30, my lord. P8, my lord.
This is lease rented Taka Mukub.
Lots.
You have not asked for discontinuation of the lease.
Prior to that, discontinuation prayer was made, my lord.
Where
Now,
is
my
that
lord,
prayer?
since, my lord, the prayer was, my lord. My lord, that prayer, my lord, page 28, my lord. Then, my lord, I can make my further representation for, my lord.
So shall these two be considered? These two.
Let, my lord, the annex Page 30 be considered.
28 and 30 let both be considered.
Both the considered, both the considered.
And till disposal of these representations, no further step will be taken
Lots of.
with regard to
Say
this.
the operation of the my lord, impute notice.
Yes.
Demand notice,
yes,
my lord.
Yes. Affidavit of service.
Huh? Person
It is contended on behalf of the petitioners that
may I submit one thing? Allow me to file a further space representation.
comprehensive representation. Very, please.
The same be considered by the authorities?
Yes, the petitioner was granted lease of the pond in question being Pransagar Dighi. Being Pransagar Dighi. Upon depositing the requisite rent and possession of the pond was handed over to the petitioner on 13th February 2020.
2020, yes, madam.
Stop. Immediately thereafter, immediately thereafter, comma, the COVID-19 pandemic intervened and the petitioner was unable to carry on pisciculture. From 23rd March 2020. Stop. The petitioners, submitted an application before the concerned authority seeking the petitioner submitted an application before the authority seeking exemption of
lease rent, my lord.
Lease rent for the period from 10th February 2020 to 23rd March 2020. Stop. Yes. Also, comma, since the petitioners are not in a position to carry on pisciculture, comma, they sought cancellation of the deed of lease. Stop. The applications went unheeded. Stop. The petitioners were served with a demand notice for realization of lease rent issued by the Additional District Magistrate and District Land and Land Reforms Officer, comma, Dakshin Dinajpur, comma, Balurghat, on 7th July 2023.
May I submit one thing?
Turning down their request for waiver of lease rent and directing them to clear the outstanding lease rents till 12th February 2024. Stop. The petitioners seek to file a comprehensive representation before the concerned authority seeking waiver of lease rent, as well as cancellation of the deed of lease, and pray for a direction upon the authority to consider the representation at the earliest. Paragraph learned counsel for the respondents submits that the fourth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent within 2 weeks. Within 2 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within 4 weeks from the date of receipt. Yes.
May I submit? In accordance with law, by taking into account the pandemic situation of the let that be.
That has already been taken into account in the earlier in the demand notice. So that will not really help. Let them consider. Because the force majeure clause doesn't apply here.
That's that I know all that. But in several occasions, my lord, the government issued several notification regarding my lord for exemption to several authorities.
Place them before the authority when you're given an opportunity of hearing, you'll be heard. Within 4 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of.
Till that time, the stay of the operation of this.
Yes. Paragraph, pending disposal of the representation, the demand notice issued on 7th July 2023 be stayed. That will disposed of.
Or direct to appear on the petitioner. Affidavit of service.
Respondents?
All have been served. হ্যাঁ সেটাও নোটিশ দিচ্ছি কালকে ফোন করে জানিয়েছি
East Kolkata Wetland Management, Mr. East Kolkata Wetland Management Authority, Government of West Bengal. So you will be representing them. Where is the service?
My lord, this is my lord service, my lord. All the respondents have been served.
All are state respondents?
State, all are state. They are the prescribed authority under the Act. And yesterday, evening time over phone, my learned junior.
May I request you to appear in this? Please serve a copy to.
My lord.
Yes, what is the matter about?
My lord, the petitioner, my lord, by way of this writ petition.
Oh, you are appearing in this matter for all the respondents?
My lord, respondents.
Yes.
My lord, I was on my legs, my lord, in court room 11. I'm so sorry, my lord.
Sorry. Yes.
But by way of this writ petition, my lord, the petitioner challenged, my lord, the action of the state respondents to include the land of the petitioner under the, my lord, East Kolkata Wetland Conservation Management Act 2006. My lord, the factual aspect of this case, my lord, from the origination, my lord, the character of the land was classified either Danga or, my lord, Sali. And this, my lord, classification has been recorded in CS record, RS record, as well as in LR record. But I will show your lordship, my lord, the records, the record of rights. First of all, my lord, kindly have a look, my lord, the deeds which I have purchased, my lord. My lord, kindly have a look, page 46, my lord. But only the schedule portion I am showing your lordship because, my lord, the land was purchased, my lord, under the category of, my lord, Shali or Danga. Lordship, kindly have a look, my lord, page 46. Your lordship will find, my lord, LR Khotiar number 1200 554. Classification is Shali. Thereafter, my lord will find, my lord, LR Khotiar number 999 520 Danga. Now, my lord, this type of several deeds are there. My lord, next, my lord, page 62.
Yes.
all these are, my lord, there, and my lord, the character, the classification of the land, my lord, was shown as, my lord, Sali or Danga. Now, my lord, kindly have a look, my lord, Annexure P2, page 200, my lord. This is the mutation granted by the, my lord, the concerned Land Reforms Authority, 200.
Yes.
This is the, my lord, the mutation granted by the, my lord, the Land Reforms Authority. My lord, total area has been written, my lord, 4.27 in plot number 520, 521, 554, and 674. So, my lord, the mutation also, my lord, granted by the authority. My lord, in the CS record, the dark numbers were, my lord, different. But in the, my lord, RS, at the time of mutation, my lord, RS record was there. And, my lord, these dark numbers were, my lord, changed from the CS dark number. Now, my lord, kindly have a look. My lord, page number, my lord, 202. This is the, my lord, the CS record.
Yes.
My lord, previously in the CS record, the dark number was, my lord, 571, 572. Lordship will find, my lord, hard number 571. That is recorded as Danga in the, at page number 202, my lord.
Yes.
And, my lord, the last 572, that is Sali. Now, my lord, in the next page, 203, Lordship will find 570, that is also Sali, agricultural. So, my lord, in the CS record, at the time of, my lord, the publication of the, my lord, CS record, the nature and character of the land was, my lord, either agricultural or, my lord, Danga. But at no point of time, there was any water body or it was, my lord, used for pisciculture or any works ancillary to the, my lord, the pond or water body. Now, my lord, kindly have a look, my lord. The page number, my lord, 224. It is very important. 224. Lordship will find.
Yes.
No, 224. No. Sorry, my lord.
Dakhila.
This is the Dakhila. This is, my lord. This was, my lord, deposited, my lord, on the basis of commercial activities. But beforehand, my lord, I will show your lordship, my lord, the RS record. Yes, my lord. 200, my lord, 14. 214, my lord. Lordship, can you have a look? The last one, 674. This is a RS record, my lord. 674, my lord. Previously, it was, my lord, 679 in the CS record. In, my lord, in the RS record, it has been recorded as, my lord, dark number 674, and your lordship will find, my lord, the measurement of the land is, my lord, 23 acre, 0.5 decimal, and nature and character of the classification of the land is, my lord, Sali. So, my humble submission with your lordship, my lord, from the beginning, the nature and character of the, my lord, the land was, my lord, either Danga or Sali. And, my lord, after mutation, I started, my lord, paying the khajana or government revenue on the basis of, my lord, commercial activities. Because, my lord, the petitioner before lordship is a, my lord, company. My lord, this company wanted to, my lord, expand the business by purchasing the land. So, my lord, it was recorded that it would be used for commercial purposes. Now, my lord, kindly have a look, my lord, the page number 225. This is, my lord, LR record. Annexure P4, page 225. Lordship will find, my lord, the name has been, my lord, Starling Fishman Private Limited. This is the petitioner before lordship. And, my lord, dark number, lordship kindly note it, all the dark number remains same in the LR record. 520 Danga, 521 Sali, 554 Sali, 674 Sali. All the four dark numbers either Danga or Sali. So, now, my lord, when the petitioner, my lord, wanted to develop the property, at the relevant point of time, the petitioner came across with the notification of the government that this land is included in the wetland area. Now, my lord, kindly have a look to the, my lord, the notification. Your lordship will find, my lord, at page 265. I will, my lord, hand over the book because, my lord, the photocopies are not, my lord, clear. My lord, my land situates at Mauja Kulveria. Did it to yourself. Lordship, kindly have a look, my lord. It has been, my lord, marked, sorry, in the book.
Yes.
These four dark numbers in the Mauja Kulveria, my lord, belongs to the petitioner, my lord, have been included in the wetland area. So, my lord, my humble submission before Lordship, my lord, when, my lord, the land which possesses the character of Danga or agricultural, well, I put this question, how these lands were, my lord, included in the wetland area? Now, my lord, I represented before the authorities, my lord, for, my lord, release of my land from the, my lord, wetland character. That is, my lord, at page, my lord, page 280, Annex 56. Before, my lord, showing that representation, I will show you, Lordship, my lord, section 10. My lord, there is provision for, my lord, conversion or mode of change of mode of use. But my case is, my lord, that it was not, my lord, possess the character of any water body. So I, my lord, categorically submit before Lordship, my lord. Why, my lord, I will pray for conversion or, my lord, the change of use of the or the mode of use, my lord, because my land never possesses the character of any manner water body or it was never used for pisciculture. And in section 10, your lordship will find even there is a provision for filling up the pond. There is a penalty clause that if I want to, my lord, fill up any pond or water body, I have to, my lord, create another water body elsewhere. But here, in this case, that question does not arise because of the fact, since, my lord, CS record, it was recorded as agricultural danga. In the RS record, my lord, it is agricultural danga. In the LR record, my lord, it has been classified as danga agricultural land. And I, my lord, verified all the papers and documents. Thereafter, I purchased the land for the purpose of, my lord, expansion of my business. Now I am not in a position to, my lord, use my land. In view of, my lord, the inclusion of my land in that category. Now recently, my lord, a publication has been, my lord, published in the newspaper, wherein, my lord, the government officials have, my lord, confessed that there is, my lord, defect in declaring some lands as wetland. Now, lord, this is, my lord, published in, my lord, in the newspaper, my lord, on 8 November 2023. Here it has been written as পূর্ব কলকাতা জলাভূমি পুনর্বিন্যাসের পরিকল্পনা. In this publication, my lord, it has been confessed that yes, there are some defects in declaring all the lands as, my lord, wetland. Now, my lord, I represented before the authorities concerned to consider my case because this land was never possessed the character of any water body. Lordship, kindly have a look, my lord, page 20, Annex P6, elaborate representation, my lord, stated everything, but nothing has been done. This representation was not considered.
Page 20.
Page 280, my lord, Annex P6. Long written representation, my lord, comprehensive representation, man, stated everything. It is not less than 20 pages.
This is a demand of justice.
Demand of justice. Demand of justice. My lord, what is my prayer before the, my lord, authorities concerned? To, my lord, recall, withdraw, and quash the government order declaring the landed properties purchased by my client to be included under the wetlands and to allow my client to convert his purchased property to the status of industry commercial after fulfilling all formalities thereto within a period of 30 days from the receipt, failing which it would be due. So, my lord, I did not challenge the notification of declaring the wetlands. My lord, I am only on my land, which I purchased. I categorically stated that it cannot be treated as, my lord, wetland.
Where is the notification?
My lord, notification. My lord, in the book, your lordship will find, my lord, notification. I have.
You are challenging this.
only with regard to my property, not the entire, my lord, notification. My lord, kindly have a look to the prayer of my writ petition. Kindly have a look to my prayer portion of my writ petition, my lord. I am not challenging the entire notification, because some landed properties are, my lord, under the classification of water body or, my lord, pond or otherwise. My lord, kindly have a look to page 35, my lord. A writ in the nature of mandamus to issue commanding the respondents.
2006 notification.
Yes, well, I came across later on, because it was not within my knowledge, because I, my lord, purchased the property in the year 2008. Thereafter, my lord, I mutated my name in the office of the BLRO, my lord. They accepted my mutation. They never stated that no, your mutation cannot be done. It is under the wetland management. Thereafter, my lord, I paid the, my lord, government revenues from time to time. But whenever, my lord, I wanted the development, I have been intervened. No, you cannot do any development in this area because this is under the wetland area. Thereafter, my lord, I made the representation that my land always possesses the character of, my lord, this Sali or Danga. But how this my land can be, my lord, included as a wetland area?
Let us hear the authority.
My lord.
My lord, may I? Okay, my lord, I'm not completely equipped with the instructions right at this moment, my lord. I would have visited your lordship, my lord, if it had taken up any date in the next week. I'll be fully, my lord.
You want to come back with the instructions?
My lord, why? I tell you, lordship, my lord, the junior is having some instructions. He's seriously ill, my lord. He's now hospitalized.
Let him.
He's
Hello, in
not
that
there.
event, my lord, my
So I am
humble
being
submission,
handicapped
because I am not
that
in
way.
the way of, my lord, seeking time, my lord, by my learned
Any
friend.
date on the
But
next
a
week, my lord,
report,
I'll
my
collect
lord,
it
a
from him.
report, my lord, a report of status or report how, my lord, it has been included in the form of affidavit be directed to file before lordship, my
Because,
lord. On
because
what
what
basis?
I have apparently
On
heard
what
from my
basis?
learned friend, well, basically this 2006 Act, well, this has already now ruling the entire lordship knows, and we cannot, with respect to the wetlands, automatically, my lord, the change or whatever it is, whatever may be the documents, my lord, it has been specified on that particular date.
No, but how can you include these lands within the?
Well, these lands at that point of time, with respect to whatever the water bodies, there has been a sketch map framed at that point of time, my lord.
What shows it's
Well,
recorded
dear,
as Sali and Danga.
but from my little what I have gone through, well, in several other matters too, well, there has been some recordings in some, there are some disputes with respect to the recordings, but ultimately this 2006, well, there has been specified that this lands, and well, those lands are deemed to be now the wetlands. Well, after
How
that,
it can be?
even if there is a record, we have to check. That's why I'm saying that's exactly mine.
Basis of some record.
Yes,
Some
that.
document. So that has to be brought.
Yes.
That is, my lord.
Come back with a comprehensive report.
Yes.
Well, that will be, if your lordship instructs me, we'll come with that only. That will be better. And a written report we may place before the court and we can rely on it. Yes, in the form
Because,
of.
my lord, this, my lord, record.
Cannot just pick and choose lands and declare.
Yes.
No, that is absolute. That is absolutely. There are some
I'm
bases.
grateful.
Some basis, yes.
Some
I'm
bases.
grateful,
Yes,
my
yes.
lord. Because, my lord, my land was recorded in the CSRS by the Concerned Land Reforms Authority.
And
it is not mine.
That is after 2006.
Yes.
So how do you reconcile, right?
Well, we'll have to specific instruction. Let there be an order for to that effect. We'll come back with an affidavit with a proper.
Well, in the meantime, status quo, my lord, only.
Not necessary. You are
Because
not under threat of.
My lord, if my lord.
Conversion part, the writ court cannot deal.
No, I am, my lord, what I am on, my lord, if they take any action on the, in respect of that land, my lord, during
Nothing, if
tenancy
no
of
construction, nothing can be done. That will remain.
Action as such. And if you are asking for a conversion, the writ court cannot deal with it.
I am not asking for conversion. In section 10, it has been provided. It has been provided in section 10 of that act that conversion can be made under section 4C of the West Bengal Land by the collector. But I am not on that. I am, my lord, challenging the notification itself so far my land is concerned.
So therefore, nothing is going to happen to the land. That will remain, my lord. He wants to construct. That is, he cannot
Then
develop only.
How you would be prejudiced if status quo order is there?
What status quo with respect to
Order is
what?
not and it's a very dangerous order. You know this. A blanket status quo order cannot be passed.
But as to the nature character, my lord,
Not necessary. That will go
then, my
against
lord,
you.
any action to be taken by the abide by the result of.
What is the necessity? You are not under threat of disposition, not under threat of anything.
Now,
You're only asking for a declaration that this land doesn't belong to the wetlands.
but my lord, if my lord, the land has been declared as wetland in the notification, that means, my lord, now the government is, my lord, insisting over that matter.
Is there any apprehension? No. No interim order is necessary in this matter. The grievance of the petitioner is that the
But one thing, my lord, may I, my lord, pray for my lord to file, my lord, this publication in the way of supplementary.
Yes. শুরুতে করুন, on prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the grievance of the petitioner, paragraph is that the plots of land owned by him and recorded as Danga and Shali in the CS, RS and LR record of rights has been included in the East Kolkata wetlands by a notification published on 31st March 2006. Stop. Learned counsel for the petitioner submits that since the plots do not plots are not covered under the East Kolkata wetlands or governed by the Act of 2006, the said notification is required to be set aside insofar as the land of the petitioner is concerned. Paragraph, learned counsel for the respondents seeks to submit a report in the form of affidavit in this regard, along with documents disclosing the basis on which the plots in question have been brought under the purview of the Act of 2006. Paragraph, let the matter appear under the same heading on 1st February. Should be sufficient.
February.
1st February.
1st February.
I am grateful, my lord.
1st February. Hello, may I take back the book? 1st February, how to 30th January matter.
Okay.
Next.
I'm deeply honored.
518.
Lord, I am for the petition. Last occasion, your lordship please to direct me to serve again upon the private respondent, and I have served.
Lordship, I am for the state. Actually, I have to take instruction, your lordship. Kindly take the matter next week.
My lord, not necessary because it's a unauthorized occupancy of government land. My lord, direction may be given to the DM. My lord, the private respondent. My lord.
Is there any urgency?
My lord, 62 Act. My lord, direction to the government, DM may be given. DM will consider and take decision, my lord.
SDO.
DM is the authority. If DM.
Where are the other services? 1, 2, 3.
My lord, 2 services I have given. Ma'am, attack to the one.
Well, Private respondents are there.
My lord. Led by Mr.
Initially, services were affected, non-servicing were again directed to serve. I have served. Yes, it's only representation to be considered by the SDO under the Act 60.
Representation.
Representation.
Page 19.
Yes, madam.
Yes.
17. 17
and 19.
দুটোই আছে তুমি এসডিও কে কোনটাতে দিচ্ছ ডিএম কে
কি আছে?
yes
Page 17.
17 and 19 both 17 is
Both are same. Both are right. Yes.
both yes
Affidavit of service.
17 is SDO yes
Paragraph, none appears for the private respondents despite service. Paragraph, the petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining their plot, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation in this regard before the concerned authority on 31st August 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the fourth respondent,
yes
the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of.
and the consequential effect otherwise again I have to come back
Automatically. Before you law. No, evidence.
Well,
Before your lordship's right.
Now, my lord, your lordship will back to 11.
Yes.
Now, after 2, my lord, your lordship will back 11.
Yes, yes.
Starts from
Yes.
My lord, may
Before your lordship's right, may I make a prayer before your lordship, my lord? My item number is 535. 535. Yes, not called as yet. My lord, the State Department, my lord, has preferred an appeal in the year 2000, and till now that appeal is pending against the order passed by the illegal collector. My lord, the petitioner is now, my lord, wanted to settle the matter amicably and made a representation before the authority concerned. My lord, my prayer before the lordship is this, my lord, lordship kindly direct the responding authority to. I cannot take up the matter like this, madam. You have to wait for your turn. Place it, my lord, if it is possible. Please mention tomorrow upon notice to the other side, I'll consider. Yes?
my lord, may I be permitted to mention, my lord?
It's not the mentioning time, sir.
543. Your lordship, the urgency is on 5th. I have to vacate the premises. Yesterday, my lord, I mentioned the matter. Before that, I mentioned before the other bench, my lord. It was granted to move the matter.
Please mention tomorrow upon notice to the other side. I cannot
My lord,
hear
I
matters
have
like this.
served notice upon all the
So mentioning notice?
My lord,
Have you served the mentioning notice upon the
that's
other
now
side?
what I am mentioning. It is
This
under
is not the mentioning time, number one, and you have to mention upon notice to the other side.
urgency, my
Please
lord,
come back tomorrow. My lord.
May I have, this is an original side matter. This is an original side matter. Since your lordship takes up ordinary side Thursday at 2 p.m., I want to mention one
There
this
was no
matter.
matter at all, actually. Yes. Yes,
Because
you
for
can-
inclusion in the list, your lordship, if it appears next week, because the time to file report by the special referee has expired yesterday, your
Give
lordship.
the number. এটা দিয়ে দেবেন তো?
The original side. I have given notice to the advocate on record.
হ্যাঁ, মিঠুন থেকে।
Deeply obliged.
My lord, if item number 11, my lord, I had talked with the petitioner. My lord, she is not ready to withdraw the matter. So, my lord, kindly
Pass
pass,
on. Yes.
kindly pass necessary order. Kindly.
Let the Mr. Day come. It's item number 11.
Item 11.
The matter will be dismissed.
Yes, ma'am.
For learned counsels for the parties. Paragraph. It is not in dispute that the plot belonging to the petitioner being plot number 116, comma, jail number 19, comma, Khotian number 46, comma, Mouja Atuhat Chowk, ATUHAT, CHAK, Chowk, comma, police station Katwa, comma, district Purbo Bardhaman, was acquired by the state by a notice issued under section 4 within bracket 1 small a bracket closed of the West Bengal Land within bracket requisition and acquisition bracket closed Act 1948. The petitioner requested the Deputy Secretary, Government of West Bengal, Land and Land Reforms Department to release her plot, since the plot was situated at the end of the entire acquired stretch of land and might not be required for the project. Stop. The petitioner, paragraph, learned counsel for the petitioner takes this court to a letter issued by the collector, Burdwan, on 23rd October 1992 to the Assistant Secretary to the Government of West Bengal, Land and Land Reforms Department, stating that release of the petitioner's land may not hamper the project. Stop. Views of the requiring body, that is, the Superintendent of Police, Burdwan, was requested in this connection. Stop. There is the earlier order of the writ petition.
My lord, earlier order is 51, page 51.
It was by the same petitioner.
It was by the
Yes, Mirago.
Yes. 50, page 50.
the petitioner's paragraph, the petitioner's challenge, apostrophe S, to the acquisition proceeding made in an earlier writ petition being WP number WP 15347 within bracket W of 2004 was turned down by a coordinate bench of this court by an order passed on 3rd March 2006. Stop. In the said order, comma, the learned court recorded that it was up to the authority to decide whether they will favor, whether they would favor the petitioner with the desired release of the piece of land. Stop. In other words, comma, discretion to release the petitioner's land was left to the authority by the learned court. Stop. The respondents have, paragraph, submitted a report in this case wherein it is stated that the petitioner's plot, which is vested in the state, is required for expansion and augmentation of police units, and release of the plot in favor of the petitioner is not at all feasible. Stop. It is also tried law that a plot once vested cannot be divested. Paragraph, in view of the above, comma, this court is inclined to hold that since the plot in question has admittedly vested in the government and is required for public purpose, comma, the prayer of the petitioner cannot be acceded to. It is also not a fact that the plot has been arbitrarily or illegally acquired by the authority as claimed by the petitioner. Paragraph, in the circumstances, comma, this court, circumstances, comma, this court is of the view that the writ petition is devoid of any merits and is liable to be dismissed. Stop. Paragraph, accordingly, WPA such and such is dismissed. There shall, however, be no order as to costs as in certified website. Since no affidavit, chat line hobe, as in certified website.
Grateful.
Next.
Well,
Well, my lord, I am appearing for the petition.
Respondents, state.
But state, my lord, it is, my lord, forcibly acquired.
Mr. Bandyopadhyay and the BSF, no one. Shishanna Bandyopadhyay. Mr. Shishanna Bandyopadhyay.
কৃষ্ণ বন্দ্যোপাধ্যায় আমি বললাম ইয়েকে যে বিকেলবেলা হবে। This is, my lord,
Yes, what is the matter about?
my lord, this is a case, my lord, where the petitioners are the owners of certain lands.
My lord, in 2015 onwards, 2015, my lord, some persons from the border security force, my lord, started fencing the plot of the petitioners. The petitioners objected to, my lord, and thereafter, my lord, they made a representation before the authority that this land was never acquired by them and this does not belong to the BSF authorities. My lord, the BSF authorities themselves, after the representations, my lord, several representations, they themselves, my lord, conducted a inquiry and requested the local BLLRO to supply an amine for measurement of the land. My lord, after, my lord, measurement and inquiry, the BLLRO has given a clear, my lord, finding at page 45, my lord, will find that these lands is never acquired by the BSF. My lord, kindly finds the this is the intimation of the block land and land reforms officer. This is the report, my lord, pursuant to the, my lord, request of the BSF authorities. In reference to above, it is stated that the demarcation of the BSF land at 60 BSF or Oradipur took place on 19th and 20th December 2018. The report comes out for demonstration that the plot number 794 of Mauja Maladipur, jail number 93 and area 72 and plot numbers 501, 502, 503 of Kuludivan, jail number 94 with an area 2.75, 0.84 and 3.34 acres are not under 60 BNBSF on Aradipur campus. The above mentioned plots are not mentioned in the LA case number such and such of Mauja Kududevan, jail number such and such, and after that, my lord, as per the records, plot number 794 of Maladipur with the area of 72 acres recorded in the favor of Jinnat Hussain, from who is, my lord, my father, who has gifted. Jimnath Hussain in Kotia number such and such, and Muhammad Shafiqul Mia, and also plot number 275 acres of the is recorded in favor of Jinnat Mia, my lord, my father, my lord, forefather. So, my lord, in spite of this, my lord, I have made several again representation at page 46, a detailed representation before their authority for, my lord, for release of the land and for payment of compensation for the time, my lord, from 2015 I have been illegally, my lord, restrained from using the my land for my purpose, and they are, my lord, blocking, and there is a clear report of the BLLRO that these does not belong to the BSF authorities.
So let them consider the representation in the light of the observation made
My
by
lord,
the BLLRO.
what I am submitting before your lordship, let them place on record, my lord, some documents. Otherwise, my lord, they will come and reject it altogether.
No, let it be in terms of the observation of the BLLRO.
My lord.
Let them dispose of in the light of the observation made by the BLLRO.
My lord.
There is a clear observation, yes.
My lord.
Otherwise, I have to wait for the respondents to appear. Let it be disposed of without wasting further time.
My lord, we have also made an elaborate demand for justice that should also be taken into consideration.
That cannot. Demand of
No,
justice.
that cannot be considered, but that can be taken into consideration because I have made a representation also there, my lord. I have stated at page 51.
That's a demand of justice.
Yes, that cannot be considered, but my lord, at the time of consideration of this, my lord, representation, my lord, my submissions in that demand for justice also.
Very well. Very well. That can be done.
My lord, I'm hearing, my lord, also.
Yes, yes, of course. None appears for the respondents. Stop, no accommodation is sought. Paragraph. The petitioner's essay for apostrophe. Grievance is that their land has been encroached upon by personnel of the Border Security Force sometime in February 2015.
Paragraph 5, my lord, kindly see
Yes,
that
yes.
was changed.
By fencing the same with iron wire and obstructing the petitioners from entering into the property. Stop. On an initiative taken by the Border Security Force, at 60 BNBSF. Stop. The BNBN for Nagpur. Battalion. BNBSF. Demarcation of the property was made by the Block Land and Land Reforms Officer, Old Malda, and by a letter issued to the Commandant 60 BNBSF, Aradhpur, ARADHPUR, Narayanpur, Malda, on 10th January 2019, the Block Land and Land Reforms Officer has stated that the plots in question are not part of the LA case being number 36/87-88 and are recorded in the name of the predecessor in interest of the writ petitioners. Stop. The petitioners submitted a representation before the concerned authority claiming release of the plots in question in their favor. Representation with the authority on 19th August 2019. On 19th August 2019, claiming release of the plots in question in their favor, followed by a demand of justice submitted on 4th March
2020.
On 4th March 2022. Stop. The representation is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph.
My lord, also for the compensation for the period. My lord, otherwise, my lord, only the release from 2015, my lord, I am been obstructed till 2024. My lord, kindly, my lord, that is why, my lord,
at the earliest and payment of compensation for the period during which the petitioners were restrained from utilizing the land.
My lord.
Paragraph. Upon consideration of the submission made on behalf of the petitioner, as well as the letter issued by the Block Land and Land Reforms Officer on 11th on 10th January 2019, this court is inclined to hold that since it is not in dispute that the plots in question have not been acquired by the respondents and are recorded in favor of the predecessor in interest of the petitioners, the respondent number who should consider?
My lord, let the district magistrate, my lord, may take the responsibility because
Not the commandant,
my lord,
not the commandant.
not the commandant, my lord.
Because since it is not acquired, district magistrate will have nothing to do with it.
No, the commandant should, my lord, should come along by, my lord, as a party, but it should be considered by the district magistrate. Otherwise, my lord, because LA is not concerned because it is not acquired. District magistrate was,
Very well. Because he is the highest authority in the district.
yes,
So,
in the district.
Kevalam, this. The second respondent be directed to deal with the representation submitted by the petitioners dated such and such in the light of the observation made by the Block Land and Land Reforms Officer in his letter dated 10th January 2019, as well as the contention of the petitioners made in the demand of justice dated 4th March 2022. Within let it be 2 months. Yes, within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Stop. In the event the representation is decided in favor of the petitioners, necessary consequential steps be taken by the authority at the earliest. Paragraph, since the respondents are not represented, the petitioners are directed to serve copy of this order along with a copy of all relevant documents, including the representation, letter of the BLLRO dated 1st January 10 January 2019, and the demand of justice upon the second respondent at the earliest. Please serve the entire copy.
My lord,
because they are
I will serve the entire copy. My lord, let that be recorded. My lord, I will give the entire writ petition to them. Because it contains all the documents.
Is directed to serve? Along with copy of the writ petition, including
annexures.
Including annexures thereto.
Madam.
Including annexures thereto upon the second respondent at the earliest. Disposed of Chatelaine. Chatelaine can begin.
But 4 times they did not appear. Well, this is
That's
the 4th
fine.
day.
I chose to dictate the order. That's fine. Next matter.
আমার জুনিয়রের নামটা দেবেন
দিয়ে দেবো যাও
Petitioner.
হয়েছে
No one for the petitioner. Dismiss. None appears for the petitioner. No accommodation is sought. Dismiss for default. Yes.
That your
It is recorded. It is stated in the case.
nobody, my lord, you're not
Very well, not today. If the list is not followed, the court can't help. Anyway, on that, not today.
We are found.
not today
14. 14.
Item 14.
And I appear for my lord, respondent number 3 and 4.
Petitioner not there, not today.
Very good. Next week. Can it be next week, my lord, something like that?
What is not today means next.
Next week, not tomorrow, my lord. Very good. Grateful.
Not today, so tomorrow.
রাজু সবই
It will be tomorrow.
এই আছে
Uh,
এটা নেই
It will be tomorrow. If you're not available, I'll accommodate.
It is very clear.
Yes.
This is very clear. Everybody.
Yes.
This is very clear.
And in that case, I have to dismiss all the matters.
Today, my lord, somebody has not followed.
And that will only increase my burden.
Yes,
That will add to my burden. I have to restore all
Yes,
of them.
ma'am, that's better. It's better to.
Not to Ajit did the something yourself.
Yes.
15 minutes I get to appear on behalf of the petition. Milord, on a much deliberation, milord, ultimately on the last occasion, the learned advocate representing the state has filed a report. Because at least, milord, 6 times, milord, I have served.
Mr. Bandapat?
Mr. Wasim Ahmed. 15.
15 number,
Mr. Wasim Ahmed, milord, handed over, milord, a report. But my allegation was that, milord, the land was being acquired, milord, under Act 1. Sorry, milord, under Act 2. Milord, that thereafter the acquisition process was not made complete. I approached before this honorable court, but kindly see, milord, the last, milord, order passed by this honorable court in the previous round of litigation. That is at page 24. 25, my lord, would get, milord, the operating portion.
Of the report?
Milord, no, milord. This is, milord, the writ petition. I am placing, milord, thereafter, milord, I shall take your lordship to the report.
Yes.
In view of such from the bar, the respondent number 2 is directed to consider the representation submitted. So, milord, pursuant to this, milord, a comprehensive representation, and ultimately this has been considered at page 33 of my lord's brief. I will not trouble your lordship regarding the entirety. Kindly takes up, milord, page 34, last paragraph.
Yes.
Kindly, milord, turns over the page, the penultimate observation.
What does this mean?
Milord, so, milord, non-placement of fund by the requiring body, ultimately they, milord, concluded that yes, the proceeding lapsed.
Yes.
Now, milord, thereafter they express their inability, that they are helpless. There is no rule prevailing in the state. Now, milord, in the report, what they have spelled out, milord, this is challenged before my lord, milord, by filing the present writ petition. Kindly takes up, milord, now the report.
I think the state needs
Yes,
to
yes,
be
milord,
there. So I'll just make it not today.
No, milord, tomorrow I have some personal difficulty, then kindly make
not
it.
This week?
Not this week, milord. Monday, milord, I shall.
Did it not this week, NTW?
Milord, may it retain its
Because
position.
I hope it will. Let us see.
Otherwise, milord, I'm sure.
I hope it will. The 2022 matter, it will.
Yes. Great.
Not this week, huh? Not this week.
Item number 16, Lordship. I am for the petition. I was praying for a week's accommodation, Your Lordship.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th January. Grateful. 3-0.
17.
State, Mr. Madhavan. State. Yes.
And, kindly comes to page 47. This is the order, the Honorable Court. And
Page 47?
yes,
Yes.
instead of going through the facts, that this is what I'm really looking for. It is contended on behalf of the petitioners that in compliance with an order passed by a coordinate bench of this court on July 16, 2015, in WP number 13976 W of 2015, the concerned authority had paid compensation due to the petitioners. However, the petitioners complained that interest on the award amount including 30% solatium and additional compensation of 15% per annum have not been paid to them. The petitioners seek liberty to submit a comprehensive representation before the respondent number 4 in this regard and pray for a direction upon them. Consider. This was the order.
Yes.
Now, we made a representation, and thereafter an order was passed. Without troubling your lordship, page 59.
Yes.
The facts are set out at page 59. Now, at page 60, the last paragraph. On behalf of the petitioners, Sri Snehashish Jana, learned advocate, Calcutta High Court, submitted Vakalatama and attended the hearing, heard him at length, gone through the all documentary evidence submitted by him as well as the of his record. It is observed that, as claimed by the learned advocate of the petitioners, the LA collector, Paschim Medinipur, is not at all responsible for the inordinate delay regarding the payment of compensation. From the preparation of LA case number 07-2006-2007 up to the declaration of award, the subject land was recorded in collector's Khatian, and the delay was due to the disposal of the court cases related to vesting and divesting before different forums such as BLLRO, Kharagpur, LRTT, DL and LRO Appellate Authority, and the respondent number 2. Respondent number 3 and respondent number 4 are not at all responsible for this inordinate delay, as the corrected Khatian in favor of the petitioner was not available during the period 2006-2015. The payment of compensation was made to the petitioners on 18/4/2016. The argument of the learned advocate on behalf of the petitioner is therefore since to be very weak and cannot be considered. So the question of payment of interest on the awarded amount is considered sympathetically, but rejected, and the representation made is not maintainable and is liable. Now, Millard, thing is that there was a spate of litigation about this vesting and non-vesting, and the whole picture cleared in 2011. After that, they didn't give anything. We made representation. And now, Millard, another thing is that act of a judicial authority, Millard, does not harm anybody. It does not prejudice anybody. Act of court. Now, that is what they are saying, that we are not responsible. We are not going to pay you. But in 2016, after I filed the writ petition, they didn't pay. Then we went in contempt. Then they paid the compensation. But 2000, even if I say anything, it was all on record. And I was litigating. In 2011, everything was reversed. Everything was clear. Still, nothing was paid. They were sitting over this till I came to court.
Let us hear the state.
And one more thing, Millard. If your lordship kindly considers 34, section 34.
Have you received copy of a report?
Report is the same thing that is more or less.
My lord, may your lordship kindly go through the report. Entire report should be my lord read. They are not entitled to get any comment of the further. Their allegation is that they have not paid the solicitation. It has already been paid.
Nothing has been paid.
Your allegation, you may submit that.
Yes, the report.
The court will consider.
Yes.
May I read out, my lord? Paragraph 3, my lord.
Of the report.
Of the report.
Paragraph 3, yes.
Paragraph 3. Before dealing with the salient allegations made raised herein, I crave leave of the Honorable High Court to consider my submission as stated below. Roman 1. That one Sumoto 7A vesting case being number such and such of the West Bengal Land Reforms Act 1955 was initiated in the name of Satish Chandra Sahu, son of Dhananjay of Rupnarayanpur, and the same was concluded on 19th April 1984 with vesting of 6.96 acres of land. Next, that the legal heir of Satish Chandra Rao, Srimati Renubala Maiti, petition. My lord, the petitioner herein preferred an appeal case number such and such before the learned district land and land reforms officer, Paschim Medinipur. Next, that the legal heir of Renubala Maiti, wife of late Nirmal Chandra Maiti, of village such and such filed an application before the Honorable Land Reforms and Tenancy Tribunal being way number such and such. The Honorable Tribunal on March 25th, 2008 passed an order with the direction to Block Land and Land Reforms Officer Kharagpur 1 to reopen the vesting case and dispose of the same with adjudication of the land involved in the said vesting in the light of section 14A of the West Bengal Land Reforms Act. That is the determination of the land involved in the vesting proceeding, whether it is irrigated or non-irrigated. Next, to comply with the order dated March 25th of 2008, the Honorable Land Reforms and Tenancy Tribunal, the Block Land and Land Reforms Officer Kharagpur 1 drew up a proceeding before being number such and such by considering the lands as non-irrigated under section 14A of the West Bengal Land Reforms Act, and a proposal was sent to the District Land and Land Reforms Officer Paschim Medinipur, video memo number dated such and such in the year 2009. The District Land and Land Reforms Officer Paschim Medinipur approved the divesting proposal of the Block Land Reforms Officer Kharagpur to rectify the records. Accordingly, video memo number dated March 2010, directing the Block Land and Reforms Officer Kharagpur to divest 4.87 acres of land of Mauja Rupnarayanpur, jail number 212, PS Kharagpur such and such. The plot number such and such, covering area 4 acre of land in shade Mauja were acquired by the West Bengal Industrial Development Corporation through Land Acquisition Department being Act number 8 such and such, acquisition case number 2006 and 7. As the land was vested, belonged to the collector, Paschim Medinipur at that time. When the land was not acquired, then it was vested under the state. Thereafter, it has been divested and recorded subsequently to the name of the petitioner. Next one I am reading. That after conclusion of the vesting case on 30th March 2010, as per order of the District Land and Land Reforms Paschim Medinipur, the Block Land and Land Reforms Officer Kharagpur 1 again reopened the vested case on June 22nd, 2010 reopened and revised his own order on March 18, 2010 and declared it on the land as vested to the state and allowed the riots to retain such and such to 10.97 acres of land on July 8, 2010. Being agreed, the petitioner preferred appeal under section 54 of the West Bengal Land Reforms Act, 1988 is the order of the Block Land and Kharagpur dated such and such. In that appeal, being case number 39 of 2010, appellate authority under section 54 of the West Bengal Land Reforms Act 1955, District Land and Land Reforms Officer Paschim Medinipur passed an order dated September 4, 2014 to the effect that the order of the Block Land and Reforms Officer Kharagpur 1 dated July 8, 2010 is quashed and directed to rectify the order dated March 18, 2000 Block Land and Reforms Officer Kharagpur and to correct the records in terms of the order of the Block Land and Reforms Officer dated such and such. As the suit lands were recorded in favor of the collector at the time of declaration of the award, the question of compensation of the petitioner does not arise at that time, very time. It is the main fact. Now they are claiming the compensation and such. In compliance with the order of the Honorable High Court dated July 16, 2015, in WP number such and such, in the matter of the Renewal of Maiti and other versus state of and after obtaining report from the Block Land and Reforms Officer Kharagpur 1 dated December 16, 2015, after hearing on February 10, 2000, the payment of compensation to the petitioner was made in respect of the suit lands on April 18, 2016 for an amount of ₹30,43,180, including solicium at the rate of 30% and 12% and addition and interest as excludes date of declaration of award. Therefore, my lady, it has been paid to the petitioner after obtaining and correction of the record of rights, including the solicium and interest thereof. But the petitioner claimed interest from the date of declaration of award till the actual date of payment of compensation of the suit lands which belong to the collector at the very time they are claiming that money. This is the case money. We have already denied money and next money. When it was vested, Then it was not. Thereafter, my lord, after correction, we have given.
Where is the calculation of payment of compensation?
That has not even been mentioned, what he's saying here. Now, if your lordship remembers,
Let him
Mahinda Singh
complete,
here.
please. Let him
Yes,
complete.
that's-
The calculation of the compensation. Compensation, solatium, additional interest.
If you lordship,
There should be that calculation separately.
Mainly, while rejecting my prayer, he's never said that solatium has been paid.
19.
Yes, yes. My lord, it is there.
That's an improvement.
18 and 9. 18 and 9. Page 9, 18 and 9. Yeah, what? Yes, yes.
Solatium 30%. This is the amount that you have received. The petitioner has received.
Yes, 30 lakhs. 30 lakhs.
Yes.
30 lakhs.
12%. ওরে যশোর দেখতে দাও
30 lakhs and odd was earlier granted.
Yes, that was all. That is all.
No, no, after calculation, 30% solatium, 12% interest.
Before the court, when this order, which I showed your lordship at page 47, they did not say that solatium was paid. Even in the order, it's not been said. Now that is an improvement that they are putting in so that the court is confused. No, that is what they are doing. Now we have paid the solatium. They have not done it. That is not something that is correct. What is not in the order itself cannot be supplemented by an affidavit.
Which order are you talking about?
This order which rejects. And before the court also, they've never said that we paid the solatium.
No, no, yes, it is.
No, at page 47, that is the court's order. After that, I made a representation. My representation is not rejected on the ground that we have paid the solatium. That you're not entitled to it. That is the ground. A new factor has come in.
Page 60 and 61 last one.
কোথায় বল?
Record সেই পিরিয়ডটা not entitled.
60-61? But the delay is not of the department. And also, my lord, the wrong recording of rights does not take away my ownership. And a judicial pronouncement or activity does not prejudice anybody. I am entitled to the solatium.
But page 60.
Your lordship sees page 60-61 when they reject it.
Third paragraph.
Not on the ground that I have received
That
solatium.
as per sole mod. Page 60 of the.
Page 60, yes.
Page 60 of the petition. Paragraph last 1, 2, 3. Third paragraph, my lord. Column 9. That as per solemn order dated 12th July 2015, the Honorable Justice Sanjeev Banerjee of Calcutta High Court passed in the petition number the quantum of compensation amounting rupees such and such in total covering land value solatium 30 and additional compensation 12% from the last notification dated such and such and date of declaration dated has been prepared afresh.
And this amount has not been received by the petitioners.
Received.
Yes, we have received it.
The subsequent amount.
No, subsequent.
No, they are claiming that period which has not been.
Yes, from 2006 to 2016.
That period which was not under the vesting.
No, that
subsequently it has been divested.
A wrong recording of rights will not take away my title.
The government is not.
No, of course. No. Of course. You have vested the right land.
Collector's question. It was under the collector's question. Therefore, it would not at the preparation of the award.
That does not.
That was a wrong record.
Yes.
And that is on the after subsequent fact, my lord, they are not there. And the
judgments which say that my title doesn't go away for a wrong recording.
Correct. Rightly rejected.
Why don't you come back on affidavits?
Well, against that, I'll do that. I'll take an exception to that.
I feel comprehensive affidavits will be required because this is all on documents.
Well, because section 34, of course,
yes,
covers me.
yes. That's why I feel let them come back with an affidavit in opposition. You'll have a chance of reply.
Opposition they have given. I'll just give.
It's only a report.
I'll give a minute. If the exception, I'll just file an exception.
You'll use an exception? to
Yes,
this
because they
report?
won't be able to say anything more than that. What they've said.
Very well. Please do that because
Yes.
that should be on record.
Yes, yes.
Because wrong recording of record of rights, the petitioner cannot be blamed.
Period,
state-
my lord, at the period, time of calculation or the declaration of the award, it was not taken into consideration. That period was it was vesting. After subsequent, and in the 2015, it has detected and it has been divested. And they're claiming that
He has.
it is out. Your lordship's
Had the
confidential.
petitioner-
Title doesn't go away.
So, yes, he is entitled in that case.
I
Please come
cannot
back
go
with an
beyond
exception.
that. I cannot go beyond the record.
I'll do that within 7 days.
I'll give you a date. Third learned counsels for the court. The petitioners have claimed you've claimed solatium and additional
Yes.
Interest.
interest.
At 50%.
Solatium and additional interest.
আমি দেখে নিচ্ছি
ঠিক আছে দেখে নাও
ভুলভাল না ভুলভাল বলার
ভুল বলে লাভ নেই দেখে নাও
চেক
তোমরাও দেখে নাও আমরা
চেক করি
আমরা আমাদের একটা ইনস্ট্রাকশন ভালো করে একটু ভালো মানে I shall come with the subsequent matter.
Yes. From 2006 to 2015, you're
Yes,
claiming.
yes.
From 2006 to 2015.
My learned friend instructs me, solatium has been paid, interest of 15% as well. That's what.
Solatium has been paid.
Yes. So.
No, I shall take instruction
Yes,
to that.
yes. The petitioner claims additional interest for solatium technique. Additional interest at the rate of 15%.
Yes, yes.
At the rate of 15% per annum.
That is their claim.
For the period 2006 from Nakin, for the period 2006 to 2015. Stop. In the report in the form of affidavit submitted on behalf of the respondents, it is recorded
আমাকে বার্তা দেয় না শুনে তো ভালো
এটা যেটা এই দাতদিনের জন্য বলে দিল
it is stated, it is stated.
2007 পর্যন্ত ইন্টারেস্ট পেয়েছে 2007 থেকে 2016
সে তাহলে ওটা এক্সেপশনে বলে দিলে কি
That additional interest to the tune of 12% as it stood on the date of declaration of award was paid to the petitioners by the authority. Stop. Since the land in question was recorded in favor of the collector at the time of declaration of award, comma, payment of compensation to the petitioners, the question of payment of compensation to the petitioners did not arise at that time. Stop. It was only upon divesting of the plots in favor of the petitioners that compensation was paid to them. Including solatium at the rate of 30% of land value and 12% additional interest. Paragraph, learned counsel for the petitioners seeks to use an exception to the report submitted on behalf of the respondents. Paragraph, please serve an advance copy to Mr. Bandhu. Paragraph, let the matter appear under the same heading on 30th January.
30th.
Next.
नाम का थी जरा
18.
my lord, I am for the petitioner. It is a remand case by the Honorable Division Bench. If the learned friend has received the instruction, then I can.
My lord, we have no briefs at all.
No.
My lord has dismissed the petition on the ground. It is a res judicata. They preferred appeal before the Honorable Division Bench. The Honorable Division Bench will remanded before your lordship, but we have returned the brief to the department, my lord. As he has not supplied any copy, my lord, we are not in a position.
On the 14th November, order, lordship's order,
but he has not
lordship's
given any
order
copy.
that affidavit of service is kept with the record. Then, my lord, that the paper book has submitted, and they have received in the paper book also the writ petition copy. And my lord,
Where is the order of the Honorable Division Bench?
yes, my lord, I have earlier occasion I have given. Have your lordship find it?
Oh, yes.
Otherwise, I shall do.
MAT
I shall submit.
524?
Yes, my lord.
It is MAT 524?
Yes, my lord. My lord. My lord.
So after this, have you served copy to the?
In the paper book also copy. And my lord, my
After
grievance is I have the grievance. My lord, kindly see that mentioned my slip. I have written the learned advocate for the state have refused to accept the notice. He will not cooperate. I may cooperate. Why not? We are cooperating. Now, harsh behave. His learned advocate.
I noticed the brief is given back. Yes.
After that, appeal was there, madam. So he
He
can't
can
accept
vote
that.
it us.
If he wants, my lord, he can raise the
Before the department.
the procedure.
He will ask. My lord, question is not that.
Have you served the GP's office
Yes, my lord.
after the matter was remanded?
No, my lord, paper book was received and there paper book, all papers
When was it received? What is the date?
Read, my lord, Matt, 11th August, and the read copy is there. Read copy is there.
When the matter has been sent back on remand, you have to file a fresh notice to the GP's office. Because once a matter is disposed of, the state advocates give back the briefs to the office. They don't carry it with them, isn't it? After the appeal has been disposed of, sending the matter back on remand, you have to serve a fresh copy.
Yes, my lord, that is the learned advocate for the state respond. He will send a notice to the GP office. I may cooperate, my lord. Again, I have said that he is not cooperating. He is not accepting the notice. My clerk has harassed. Harsh word has been used by the learned advocate.
কেন মিথ্যে কথা বলো কোর্টকে?
মিথ্যে কথা তো আমি
শুধু নোটিশ দেবে, কপি দেবেন, আমি নেব কি করে? আমি কোর্টে এসে কি বলবো?
He has to be served with the brief. The matter has been disposed of. It is being heard afresh, a de novo hearing.
My lord, today will not be hearing will not be done.
Please serve the GP's office and
order
come back.
mention the order and order be passed, my lord, that I shall serve them copy, my lord. And also mention that he will cooperate with. He will cooperate with me. Notice refuse করবে না, নোটিশ কি রিফিউজ করবে? আশ্চর্য।
Mr. Bandyopadhyay, you have appeared in this matter even after the matter has been remanded.
My lord, yes. Kintu we have given, my lord, the appeal after disposal of the appeal, we have sent it to the department.
No,
There
no,
is no
after
copy
disposal of
recall.
the appeal also, you have appeared in this matter.
Yes, let them serve a copy of the writ petition. I shall appear. What is the wrong?
Please serve a copy of the report.
Yes, sir. What?
Kindly order the first. Order the first that
difficulties?
the petitioner will supply a copy.
Learned counsel for the state respondents submits that he does not
ক্লার্কের সঙ্গে মিসবিহেভ করবে নোটিশ নেবে না
possess
করতে হবে না
a copy of the writ petition and annexure thereto.
It is not an advantageous
Paragraph,
position.
the petitioners are directed to serve a copy of the writ petition along with annexure thereto upon learned counsel for the respondents at the earliest.
And my lord, that notice should be received. My clerk has returned from that.
That was a mentioning notice, sir. That part is over.
Yes, sir, that this notice will they will receive.
Please serve a copy of the writ
Yeah, I
petition.
shall serve.
I'll take it up on the next
Yes,
day.
yes.
Paragraph, let the matter appear under the same heading on 1st February.
1st April.
1st February. Next.
It বলে advantage position.
19.
নোটিশটা নেবেন না
এই সনিদা এই Sumitra sir 19 Lord, this
Yes.
matter was last occasion direction was given to
Bandyopadhyay report. Copy today.
then I have to gone through otherwise my lord thou copy thou not
Land utilized without acquisition.
already acquisition proceedings already done. Lord, the subsequently notification has been given, land is not required. Withdrawn, that is the withdrawn. My responsible submission
To
for
ask for compensation.
compensation.
Please go through the report and come back.
Yes, my lord. Not a short date, my lord.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph, copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph, on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st February.
Or the in place of 1st February or the 2nd February or 3rd February.
2nd February.
1st February only 3rd one type of
20.
not so yes.
Item 20.
Not today. You are appealing. Let it be not today.
21.
I am for the petition. I am for the private respondent.
State.
চন্ডিদা ছিল তো
Mr. De.
The previous occasion, Lord,
Where is Mr. De? He was here just now. Oh, yes.
he was here.
Mr. Day is there, we are rest assured. Representation was be there.
What is the matter about?
My lord, the land in question, my lord, is classified as Pukur.
Classified as?
Pukur. When she purchased the same, that was Pukur. Lord, you can see the deed only once in page number 30.
Yes.
In the middle portion, Lord, you got it. Dag Sreni Pukur. Middle portion. 1, 2, 3, 4, 5, 6 column. And top at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 column.
Yes, Pukur.
Sreni Pukur.
Yes.
Lordship, in page number 37, Lordship come.
37.
37.
Yes.
They are also Sreni Pukur. In the 3 line above,
Yes, yes,
Sreni Pukur.
yes.
Lordships, can you see the petitioner made in the record of rights also, the classification is Pukur. My lord, what happened? All of a sudden, filling the land, construction started. But we, the petitioner, along with some other petitioners and along with some other, made a complaint before the Pradhan of the concerned Gram Panchayat. Pradhan immediately annexed a P2, my lord.
Is this your pukur? Your land?
No, no, no.
Then?
That is using for common people.
How are you affected?
Affected, my lord. If
As
the
a
pond is
villager.
filling up, my lord, no one can use that pond.
So as a villager, you're affected.
Yes, my lord.
So this is a public interest litigation.
No, Lord,
On the earlier occasion, my lord, I took the plenary point.
And my lord, kindly hear me. Lord, thereafter, all of us made representation, all of us, before the video. Lord, kindly come to page 54, 56.
Yes.
The block development officer, Bharatpur 1 development, Bharatpur Murshidabad.
Yes.
Thereafter, no steps have been taken.
This is a public interest litigation, sir.
Apart from that, my lord, this is not maintainable. Why, my lord? Can you turn to page
If your lordship
59?
Then I am withdraw, liberty to file a public interest litigation.
Page 59. Can you turn to page 59?
I am withdrawing and I am paying leave to file a public interest.
Nature of land, my lord, can you consider? Page 59. Body.
Sreni.
That is my case.
Yes,
All
there
of a
is
sudden,
conversion.
wrongly
Illegal
recorded.
conversion. I am not on that. That is illegal conversion under section 4C of the West Bengal Land Reforms Act.
This court will again not.
Yes.
I am
The
praying.
PK is also maintainable, my lord, can you consider?
But the prayers is not with
Filling up the
regard to illegal filling up.
filling up pond. It has converted, already conversion.
Yes,
Now,
filling
if
of
the
that.
illegal construction is made on the basis of illegal filling of the pond, then, my lord, this recording is illegal also.
The same directing the concerned authorities for taking
Let
steps.
him withdraw and approach the appropriate forum. Let the appropriate
That
forum
is only way, because if your lordship kindly direct the appeal, then this argument cannot be made with the.
No, in appropriate forum.
Yes, yes.
The conversion is not challenged.
Yes. Indirectly, because he is challenging that in the record, there is a deed, is a
If I challenge the conversion, then I shall have to go.
What he
Land
cannot
acquisition
deal
tribunal.
in a straight way, he cannot allowed to be done in some other way.
It has been very nicely drafted.
But it
Conversion
cannot.
has not been challenged because it goes before the tribunal.
Yes, that's why.
I have not challenged that. I have challenged.
If he did not challenge the recording.
Okay, this is the nature of a public interest litigation.
Well,
the subject matter of the writ petition is in the nature of a public interest litigation. Paragraph, the petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance. Petitioners, redressal of their grievance. Paragraph, in view of the above, the writ petition being WPS such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. There shall, however, be no arrest to cost as in certified website copy.
Item number 21, na?
Next.
Grateful one. Not everything is publicly kept on record.
Rajiv,
Oh, on the previous day,
It's on record already.
Inspector London Advocate Pushinjit Mukherjee is appearing. He is on legs for the courtroom number 4, Lordship.
You're asking for an adjournment?
No, Lordship, if your Lordship kindly give me a short pass.
Not
Very
possible
short.
in court, I'm sorry. Why don't you make the submission?
I do not have the brief, Lordship.
Yes. You're aware of the facts?
Lordship, this is the unauthorized construction I have just instructed, Lordship,
Yes.
in the PWD road, Lordship.
Carry on, carry on. Yes, you're correct. Where is the service?
Lordship,
Private
there is a
respondents are
affidavit
there.
of the service.
Have you served the private respondents? There are 3 private respondents.
Lordship. Service has been effected, Lordship.
Yes, unauthorized occupancy. Yes, that's why I asked him to continue. Yes.
Yes, Lordship.
This is PWD road.
PWD road, Lordship.
Where is your representation? Page 74.
P5, Lordship.
74. '73. Yes.
73, Lordship.
Can this be considered?
Lordship.
Yes.
Lordship.
Affidavit of service. None appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road adjoining his plot, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority on 18th October 2022. 18th October 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
Lordship. I'm grateful, Lordship.
And give your name.
Lordship. I'm grateful.
Next.
23.
Yes. Not today.
Well, at item number 24, I am appearing on behalf of the petitioner.
You are appearing for?
Petitioner, my lord.
Petitioner?
Yes, my lord.
23 petitioner. 23. I'll take up 23. The petitioner is here.
Lordship.
Lordship.
You are appearing for?
Lordship, in this matter, your lordship, initially a writ petition was filed by the petitioners. Over there, lordship, the concerned authority, the executive engineer, has stated that the land does not belong to the PWD, but the land belongs to Sundarban Development Authority. Lordship, it is on page number. Lordship, page number 36, your lordship. Page 36.
Mr. Dey is appearing in this matter. No private respondent?
Lordship, this private response service has been completed, lordship.
Where is your service? Where is the service? This is the restoration application. Service with regard to the writ petition?
Lordship, I shall serve it in the course of the day, your lordship. It's served, your lordship. I couldn't carry the brief, your lordship, in the hurry, therefore, your lordship. I shall serve it in the
I'll
course.
just make it not today.
Okay.
Right? Yesterday, not today. Let him come back with service.
Yes.
My lord, I am appearing on behalf of the petitioner, my lord. My learned junior is present there in court, my lord. Lordship,
Mr. Shantanu Kumar Mitra and Abhishek Banerjee is appearing for the state, praying for not today, Lordship.
my lord, may I pray one thing, my lord? Already a report has been filed before the Honorable Court on 6th of September. My lord, the order shows that, reflects from the order, my lord, that they have filed the report, but no copy has been handed over to me as yet. Now, because, my lord, there is no order, no. Because there is no order of this Honorable Court, and matter had been dismissed for default and restored back on 10th of October. On that day, my lord, my learned junior appeared in the matter. He had prayed verbally before the Honorable Court. Then the Honorable Court also directed, I rather requested the learned advocate. But till date, no report has been handed over.
Copy of the report, madam.
My lord, let there be an order so
I
that
will,
they can.
yes.
Yes.
Copy of the report in the form of affidavit submitted on behalf of the state respondents has not been served upon the petitioner till date. Stop. The state respondents are directed to serve copy of the report to learned counsel for the petitioner in course of this day. Paragraph, let the matter appear. Are you
I'll
asked?
use an exception, my lord.
Paragraph on prayer of the petitioner, liberty is granted to use an exception to the report, comma, if required. Paragraph, let the matter appear under the same heading on 5th February.
My lord, may it be taken up on 5th February, yes, my lord.
Yes.
But my lord, 5th February, I think that will be the day when the combined
Please
list,
come back,
monthly
let us
list.
see. And please serve an advance copy also.
Lordship,
Your
lordship.
exception.
But it may it be only kept on 7th of February in the supplementary list, because my lord, the petitioner is suffering.
Supplementary list. You're asking for 7th of February.
My lord.
7th February.
Lordship.
Yes, next matter.
Obliged, my lord.
Lordship, I am for the petitioner.
You want to appear for the Digha Shankarpur development?
Lordship, on the last occasion, this matter appeared to the Honorable Josh Patnaik, and on that day, my learned friend on behalf of the Digha Shankarpur Development Act, for which Lordship, another order of service was directed, and this is the affidavit of service.
Mr. Bandopadhyay, you're appearing.
Lordship, application praying for consideration of my representation in respect of Section 4 of the West Bengal Acquisition of Homestead Land for Agricultural Laborers, Artisans and Fishermen Act 1975. Lordship, your petitioner is a poor farmer, as well as he does the work of a fisherman also. And he lives on a land of 0.5 decimal at the village Palsandapur, Police Station Digha, under the Digha Shankarpur Development Authority. And Lordship, your petitioner is praying for patta as he is entitled as per the Section 4 of the said Act. And Lordship, he made twice representations, annexure P1 page 12 and annexure P2 page 15. And Lordship, my prayer is only the consideration of my representation, that is annexure P2.
Yes.
My lord, may I? I believe your lordship doesn't have the act. My lord, I've got the act.
Do you have any objection to deciding the representative?
Or 1 or 2 points only. But kindly takes the act once. It's a very small act.
Yes.
But kindly takes first Section 3.
Yes.
Nothing in this act shall apply to any land. Kindly comes to B. Belonging to or taken on lease by any local or statutory authority. Number one, I do not have the annexures with me. These written instructions which I have received clearly state that, my lord, this particular plot of land that my learned friend is referring to
my lord, is under the Khotian of DSDA, Diga Shankar Development Authority, which is, and my lord, it has been now classified as Jhaubon, handed over by the government after acquisition. My lord, development works undergoing for a long time. Number one. You know, number two, kindly seeks now section 4, which my lord was relying on, where an occupier has been in possession of any land on the 26th of day of June 1975. Specific cutoff date is there. Lordship, my lord, I have not been able to find from his representation. My lord, he says I am residing there for some time. No details given. That is one point. The second point is, my lord, handed over to the Diga Shankarpur Development Authority by the government after acquisition. And my lord, the development work is continuing for long. So, my lord, that those are impediments over here. If your lordship wants, I can file a report to that extent.
The report will not really improve.
Kindly have a look at the representation. One is to me, that is of no use. Then the only thing is at page 12, the representation to the district magistrate. Kindly see.
Let us see how the petitioner responds to your query.
Not only one thing, kindly see page 12 once. অধীন আবেদনকারী নিবেদন এই যে অধীন উপরোক্ত ঠিকানায় স্থায়ী বসবাসকারী ব্যক্তি হইতেছে নিম্নলিখিত জায়গায় যাহাতে দীর্ঘকাল হইতে পরিবার. There is no date specified. And my lord, it is that the record, that is development work is going. Those are the 2 points.
Will you be able to produce relevant documents before the authority when the representation is taken up for hearing?
Lordship, then kindly do one thing. I will file a supplementary affidavit mentioning the exact type from which I have been living here. And kindly, Lordship, allow me to file a
39 years.
supplementary affidavit.
Not necessary. Why don't you file a
Right, sir.
comprehensive representation before the authority? Instead of wasting further time with a supplementary affidavit, file a comprehensive representation before the authority in terms of the act. Yes, you are aware of the requirements.
Only
So, substantiate that you are entitled. You have to prove your entitlement, isn't it?
From the lordship, from the affidavit, he is 39 years of age, so he cannot be there from 75.
Predecessor, take a positive approach.
Only logical thing, but is not there in the representation or in the governments.
Predecessor is not in the picture at all.
Not in the picture at all.
You say that you have been occupied.
That's right. He's 39 years.
So how can you occupy?
On 76, he must be there. Otherwise, he has
75.
75.
So you are not this act is not applicable.
It does this act, this act doesn't apply.
But to file proper representation before the concerned authority, and they will consider my representation. That is
They will consider and reject. You can make it out here and now. How will it help you? You have to be in possession on 26 June 1975. You were born in 1976, sir. So how were you in possession in 1975? Have you seen section 4? How will this help you? The writ petition. Yes. I can give a direction for the consideration. That will not help you at all. You have to comply with the requirements. Yes. What will you do?
Why he have to take?
39 means 72 bond.
No, cannot be. I am 72 bond. It cannot be 39. It has to be much lesser than that. I tell you also 39 as in 2022. So it has
43, 80.
39. বলো না তুমি তো অঙ্ক ভালো
আরে 39 মানে অনেক আছে
39 75 25 আর এতে 47 আছে
85 টাইপে চলে
should be around 84 85 1984 85 like roughly.
Yes.
So my lord, he is not entitled.
84 85. And this should be from same. What will you do with the writ petition? I have to dismiss it on this ground.
Lordship, kindly pass appropriate order. What should be done?
Appropriate order.
I have to dismiss it, sir. No other option.
Yeah. ওইটাই মুশকিল
The petitioner
Lordship, then kindly give me to withdraw the petition. Give me liberty to withdraw the petition.
Very well. Let him withdraw.
Yes, yes. The difficulty was that I wouldn't have objected. Difficulty was that this would have opened the floodgates for other representations like.
Statute itself. You can't help.
That's right.
We cannot amend the statute, isn't it?
না আমি তো অথরিটি নেই
The petitioner seeks to.
আমাকে রিপ্রেজেন্টেশন বা কেন করেছে সাইয়া
It is submitted on behalf of the petitioner that the petitioner does not intend to proceed with the writ petition any further. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. There shall, however, be no order as to cost, as in certified website copy.
Advice now.
Bad luck, sir.
Huh? Yeah, that's.
Even if it's you can take that.
That I'm deeply obliged. And I had no idea of the existence of this act. That's.
We live to learn.
But I at least.
All of us. Speaking for myself, I learn every day. We are dealing with such a vast
The
subject.
greatness of your lordships.
We are dealing with such a vast subject. It's so dynamic.
Absolutely. I'm deeply.
You cannot shut your windows and doors, isn't it? That stops everything.
I'm deeply.
January to February. 8 থেকে 22 মনে রাখবেন। তার কেটে যাচ্ছে। Okay. 4th. Yes, next matter.
26.
Oh, no petition and not today.
27.
I am for the statement, not for the.
I'm for the private respondent, 5 and 6.
What is your prayer?
After the demise of Ali Kadir Vishwas,
yes.
The petitioner is the legal heir of the land in question in respect of RS numbers, RS Twitter number 974, 975, and 480.
You are asking for correction of record of rights? This court will not have jurisdiction, madam. I'm sorry.
And consider it before the BLRO.
You have to approach the appropriate forum. This is a specified act, the Land Reforms Act. This court will not have jurisdiction to deal with it.
My lord,
Approach the appropriate forum.
my lord, the case is pending at the district also. They have the, meaning my client, private respondent number 5, got the land by through a registered will.
Merits at all because
Yeah,
this case will not be made to the courts.
Okay.
You have to approach the appropriate forum and grant you liberty. Okay.
Thank
Affidavit of service. Paragraph, the matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, the petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of this grievance. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall, however, be no order as to costs as in certified by second. Affidavit of service. Next.
28.
My lord, praying for not today. Lordship, Govind Chandra Vaidya is appearing on respondent number 9 to 10. Due to his family urgency, he left the court.
Not
kindly fixed tomorrow, Lordship.
Not today. Not today.
29.
I am for the petitioner.
I'm for the state, Your Lordship. I'm led by Mr. Ashim Kumar Ganguly.
You ready?
Yes, Your Lordship. They on the last occasion there was an order for filing of exception to the report that we had filed.
My lord, kindly extend the time, my lord, so that we can, due to the problem of the petitioner itself, my lord, I am ready, but my lord,
Some more time
no lordship. My lord, in 4 matters, my lord.
on prayer of the petitioner. Learned counsel for the petitioner seeks extension of time to submit the exception
চারটে দিয়েছো?
with the report filed by the respondents. Paragraph, let the matter appear under the same heading on 5th February.
Lordship.
Great.
না না না
Next.
30, 31, 32, same.
30,
31, 32, 20.
30, 31, 32.
21, 39, 20, 29, 30, 31, 32.
Extension and all the matters.
I'm straight in the item number 32.
30, 31, 32, same order. Vashu.
Grateful for it.
Next.
কি দিল অর্ডারটা কি দিল দাদা?
এক্সটেনশন করলো, এক্সেপশন
কতদিন এক্সটেনশন?
5th February আসবে আবার।
ঠিক আছে।
33.
33, my lord, I am for the petitioner. I beg to appear for the petitioner, my lord. My lord, my grievance is against KMC authorities. And my lord, kindly see the last order, my lord.
Where is Mr. Ghosh?
That's the problem, my lord. I cannot enjoy my property. They are hanging on to my property. They are not mutating my name in the KMC records. No acquisition, nothing had happened. রোজ রোজ ফোন করে তাকে আনা যায়? আমার তোমার ধনঞ্জয় নাম, ম্যাডামের নাম।
You're enjoying an interim order.
Yes, my lord,
I'll record that even in their absence, I'll hear the matter on the next day.
my lord.
None appears for the Kolkata Municipal Corporation. Stop, no report is also submitted. Paragraph, let the matter appear under the same heading on 31st January.
My lord.
Paragraph, it is made clear that the matter shall be taken up for consideration. The matter may be taken up for consideration on the adjourned date, even in absence of the KMC. Please inform him another once more if you can.
I rang him up. Always I do before. Empty prayer, please.
34, 35, 36.
Yes.
Same matter, man. I am appearing on behalf of Barwan Development Authority, man.
What about the petitioners? Not today.
Or kindly fix the date, man.
Not today, not today, not
Not at a date.
Are not today, মানে কি?
Next.
কালকে হবে কিনা ফোন করে নেবো।
Same matter, man, same matter.
35 and 36. Not today, not today.
34, 35, 36.
34, 35, 36, not today.
37.
Not today.
38.
My lord, this matter has been disposed of with the earlier occasion in 29th March 2023.
38?
Yes, my lordship.
I'll just check. I'll find out. I have the file. File আছে নাকি?
Fine, থাকবে না, dispose of হয়ে গেছে বলছে।
By the Honorable Justice Sabyasachi Bhattacharya, court number 9.
Please show me the order. File name.
Kindly, your lordship, kindly see the page number 7. This is okay.
38 is 28744. Oh,
Taposh Ranjan Das.
Taposh
The combined matter, the Taposh Ranjan Das and the Manas Ranjan Das. This was a electricity matter, and I was the petitioner in this.
No order need be passed. Yes? Only 3:30. Another half an hour, 4 o'clock. Let me call few more matters. I wanted to dispose of because there are so many pending matters.
They are not interested.
Very sudden change.
Not sudden 24 hours notice, sir.
This is happening for the first time.
No,
I believe.
list indication was in the list.
We were under concept after second half.
No work.
No, because no one is going through the indication.
Indication.
No one is going through the indication.
Exactly.
And my
Both are the
difficulty is I
combined
wanted to
matter.
dispose of some matters.
I'm lucky enough that my clerk followed me. That's why I'm here.
Yes, next matter. I'll just call a few minutes. 39.
39.
Not today. देखिए जान देखिए कौन सा है.
40.
Not today.
41.
Not today.
42.
Not today.
43.
Not today.
44.
Look, 44 while in this matter, I am appearing on the respondent number 9. But Mr. Joyanta Das is appearing for the petition.
Not today.
Not today, not he is taking time 2 weeks because he is seriously ill. Pacemaker will be placed.
Oh, very
So for this reason, at least
This is 44.
44. 44 seriously ill. He ran.
Record Corbin, none appears for the
court.
petitioner. Paragraph, let the matter appear under the same heading on 6th February.
6th February. Yes, deeply obliged. Yeah, or pacemaker. Devashish Das, respondent number 9.
45.
45, not today.
46.
Not today. Not today.
48.
Not today.
49.
Not today.
50.
I am for the respondent number 6.
No petitioner. Didi, Themejan, not today. Let me stop here. Unnecessarily, I'm just dragging the list. এখান থেকে নিন নট টুডে করলাম তো সব 41 থেকে নিন 41 থেকে নিন প্রথম থেকে নিন 41 থেকে নিন Mr. Day, you can go home. I think Mr. Day can go home now. No use calling further. No one is.
My lord, the same heading will be followed under the
The same thing will be repeated.